recognition, and enforcement. Now, once an award is made, it is recognized. So there is no need for an order to recognize the award. But Section 57 now says, an arbitral award shall, irrespective of the country or state in which it is made, be recognized as binding. And an application in writing to the court be enforced, and the provisions of enforcement as stated under Section 58. What this means to my mind is that you don't need to apply to recognize an award, but you need to make an application to enforce it, because upon being made, it is deemed recognized. Two modes of enforcement of an award: by enforcement of the award and by action of the award. And action of the award is based on the implied agreement of the parties, and of course, you can also enforce part of an award, as laid down in the cases of INPO Nigerian against NNPC and NNPC against INPO. Section 58 also sets out grounds for objecting to the recognition and enforcement of an award. Enforcement under the New York Convention, Nigeria is party to the New York Convention, and without the ability to enforce the awards pursuant to the New York Convention, international arbitration will be a far less attractive proposition. The purpose of the New York Convention is twofold. First, it recognizes the importance of private agreements to arbitrate, and secondly, it seeks to limit court intervention into the arbitral process by providing that arbitral awards issued in one contracting state can be freely enforced in another contracting state, subject only to certain limited circumstances. The power to set aside an award is in Section 55 of the ALA, and the application was made within 3 months from the date of the award. Now, Section 55 has done away with the concept of misconduct, which actually led to the building of a big jurisprudence in Nigeria. And of course, it has always been something that lawyers have used to re-argue the case. And of course, the courts are not expected, when looking at an award, to sit above the arbitrators. You are supposed to sit at the same level with the arbitrators, and an application to enforce or set aside is not an appeal. So the courts are not expected to go into the merits of the facts. And also, under Section 55, subsection 2, the ground of error of law in the face of the award has been whittled down. So, for me, this is a game-changing position and stated to, as it were, rein in the attitudinal mindset of appealing the merits of the award under the indefinite ground characterized as error of law on the face of the award. It is also instructive that the ground of misconduct no longer applies for the purposes of setting aside the award. Now, what is the extent of the court's intervention? And here, we have a dichotomy in the sense that can the courts restrain local arbitration? Can the courts restrain foreign arbitration? In the case of Statoil, Nigeria Limited against NNPC, the Court of Appeal held that the court cannot issue injunctions to restrain arbitral proceedings on the ground that there is no provision for such interference in Section 34 of the ACA. So Section 34 of the ACA does not give the courts the powers to set aside, to restrain foreign arbitral proceedings. Now, in the case of Statoil, in the case of Shell Petroleum Development against Cresta, the Court of Appeal made an order of injunction restraining the appellants from proceeding or continuing with or taking any further steps in arbitration proceedings with the ICC. This gives some room for concern because the ICC is an internationally recognized body, but then we look at the rationale for the decision. It's obvious from the above provision, that's Section 57(2), that the instant case is an international arbitration which falls within the ambit of paragraph 6(1) of Section 57(2), to the effect that the place of arbitration is situated outside Nigeria, where the parties have their place of business. The Court of Appeal actually relied on English authorities, which also relied on the Senior Courts Act. And the Senior Courts Act is in pari material with Section 13 of the Federal Court Act. So the Court of Appeal looked at the case of Excalibur Ventures LLC against Texas and stated, it is clear that the English courts have jurisdiction under Section 37 of the Act to grant injunctions restraining arbitrations where the seat of the arbitration is a foreign jurisdiction, although it is a power that is only exercised in exceptional circumstances and with caution. Question is this pro arbitration, and of course Section 13 in my view can also be used to support the principle of anti-suit injunctions laid down in the Western Tankers case. Now there is in Nigeria a policy of upholding arbitral awards. There is a narrow compass for the setting aside of awards. The court should be slow in interfering unless compelled to do so. And the words of Top-One LJ Rehopper read out loud, clearly. And it says, we must not be over ready to set aside awards to abide by the decision of the tribunal of their own selection, unless we see that there has been something radically wrong and vicious in the proceedings. Of course, this same dictum was applied by the Honorable Justice Obitade then in the Court of Appeal, retired as the Justice of the Supreme Court in the Bokan against Ekwenebe and Sons Trading Limited. So there's a policy of reluctance in setting aside arbitral awards. But there is a recent development, and it's the case of Imagine Markets Telecommunication Services Limited against ADFI, delivered on Friday, 6th of March 2026. An objection has been raised to the competence of the appeal. The Supreme Court noted the objection had merit, but proceeded to determine the substantive appeal, relying on Section 22 of the Supreme Court Act. And Justice Tijani Abubakar said these words, which for me reaffirms Nigeria's principle of being a pro-arbitration nation, apart from the legislative intervention needed as regards Section 20. However, in my humble understanding, this is not the end of the matter. The appeal before this court arises from proceedings concerning the recognition and enforcement of an arbitral award under the AMA 2023. Proceedings of this nature are not ordinary civil contests or matters occurring from day to day in our courts. They command commercial importance and impact on the perception of our jurisdiction by the international commercial community. They are sui generis. They implicate the sanctity of arbitral awards, commercial finality, and Nigeria's standing within the international arbitration regime. Arbitration rests upon the pillars of party autonomy, expedition, minimal judicial interference, and finality. Therefore, while procedural compliance is fundamental, not every procedural defect is jurisdictional in this strict sense. The present defects, grave as they appear to be, do not deprive this court of its constitutional jurisdiction under Section 2233 of the Constitution to delve into the merits of the appeal and examine some fundamental issues of commercial importance to our jurisdiction, and allay the fears of investors who always think that arbitration in Nigeria marks the beginning of long and endless journey to the apex courts, journey full of impediments, hiccups, hurdles, and uncertainties. This court is not merely a court of technical rules, it is above all a court of justice. The issues raised are of considerable jurisprudential importance and bear upon the interpretation and application of Nigeria's arbitration regime. To strike out this appeal at this stage would not terminate the controversy. It would likely spawn further proceedings, deepen delay, and undermine the very policy of expeditious determination which undergirds arbitration law. It is a common precept that it is in the interest of the state that there be an end to litigation. This court must not encourage procedural indiscipline. The appellant's defaults are neither trivial nor excusable. They are deprecated in the strongest terms. Justice is not served by sacrificing determination of the substantive matter to the altar of technical rigidity, especially when the decision of the court remains intact and real issues in controversy between the contending parties call for authoritative resolution.
In the peculiar circumstances of this case, and having regard to the nature of the proceedings, the wider commercial and systemic implications, the fully crystallized state of the record, and the constitutional mandate of the court, of this court, that is the Supreme Court, to settle the law, I am satisfied that this is a proper case for the exercise by this court of its inherent and statutory powers under Section 22 of the Supreme Court Act to proceed to determine substantive appeal. All along the line, the court persistently scratched the matter on the surface. This court must not scratch the appeal on the surface once again by halting and dropping its pen at the submission of the preliminary objection. I must delve into the merits of the appeal on the merits to set the record straight. So the Supreme Court did not drop the baton. The Supreme Court held on to the baton in this third leg of the relay race. To do otherwise would elevate procedural compliance above substantive justice in a matter where commercial finality and certainty are paramount. The law does not command such inflexibility. Accordingly, while the preliminary objection is meritorious and the court expresses its firm disapproval of the appellant's glaring and deliberate non-compliance with subsisting positive orders of court and mandatory rules, the peculiar character of these proceedings and the imperative of finality in arbitral jurisprudence justify a departure from the ordinary consequence. I am convinced that as a policy court, this court may, in exceptional circumstances, especially involving the economy of the nation, confidence of investors and public interest, proceed to consider an issue beyond the preliminary objection, even where the objection is found to be meritorious, just to strengthen arbitral jurisprudence and reset the arbitration governance framework in Nigeria. The preliminary objection is noted and its merits acknowledged. However, in the interest of substantial justice, in furtherance of the policy of finality underpinning arbitration law, and pursuant to the power of the court under Section 22 of the Supreme Court Act, this court will proceed to determine the merits of the appeal. This is a clear declaration of the pro-arbitration stance of Nigerian courts as laid down by the Supreme Court. So the Supreme Court held onto the baton post-award, even when the runner had tripped and almost fell or did fall. Now, there's another policy that we have in Nigeria, and that is the written policy of emphasizing pro-arbitral stance by circular. The then Honorable Chief Justice of Nigeria, the Honorable Justice W.S.N. Onoye, TCON FNGI, requested all heads of court to issue pro-arbitration practice directions. The reasons are that people were now beginning to ignore arbitration clauses, and that no investor, whether domestic or international, will want his investment tied down in seemingly endless litigation, especially where there is an arbitration clause. So his lordship then said, "May I draw to the attention of my lords, heads of courts, that the time-saving nature of an arbitration proceeding encourages heightened commercial and economic activities and foreign investments, and therefore needs the support and encouragement of the judiciary." The Chief Justice, the acting Chief Judge of the Federal Court, Honorable Justice Ato Kafarati, as there was, and later Chief Judge and of First Memory, then issued a practice direction on the 27th of September 2017. The imperative of the practice direction reads, the operative part reads, that the court shall not entertain any action instituted to enforce a contract or claim damages arising from a breach thereof, in which parties have by consent included an arbitration clause without first ensuring that the clause is invoked and enforced. That the court must insist on the enforcement of the arbitration clause by declining jurisdiction. That upon the issue being raised by any of the parties or the court is at liberty to raise the issue so motu and decline jurisdiction accordingly. Where a party insists an action in court to enforce breach of contract containing an arbitration clause without first invoking the clause, he himself is in breach of the said contract and ought not to be encouraged by the court. Pacta sunt servanda. That the court, upon declining jurisdiction, may award substantial costs against the parties engaged in the practice. And this brings to my mind the provisions of Article 15 of the arbitration rules, which encourages more or less cost on a reimbursable basis. We've not got to reimbursable basis yet, but it encourages costs that are slightly higher than the normal costs that we are used to. And of course, We have seen an improvement in the cost regime in our judiciary. Supreme Court has awarded, real life costs in many matters, sometimes punitive, but then of course, where lawyers overstep their bounds, the Supreme Court should be able to discipline them. There was a case in which the Supreme Court ordered a cost of 50 million naira to be paid personally by the lawyer within a time frame. So, it is not in dispute that practice directions cannot override the provisions of statutes such as the AJA or AMA. It is, however, important to emphasize that there is a pro-arbitration approach by the Nigerian courts, which has been declared at the highest levels of the judiciary. There is a clear judicial policy towards supporting arbitration. I cannot overlook sections 19 and 20. Legislative intervention is important. Section 20 clearly drops that and truncates the case. But the EMTS case shows that with the right guidance, the race can be successfully completed. Is there ever hope that very soon, the Supreme Court of Nigeria will have the opportunity of making a definitive pronouncement on the effects of Section 19 and 20 of the AJA in view of its previous decisions on the effect of the arbitration agreements? The EMTS case and the practice directions are clear indications that the Nigerian courts are pro-arbitration and that policy has come to stay. So, the baton is still intact at the end of the race. Thank you very much, my lords.
Another round of applause for the speaker. I told you that it's going to be an interesting delivery, and he has lived up to expectation. We'll have time for questions, and so I will straight away call the second speaker, and then thereafter we will have the other contributors. And then finally, we'll have time for questions. And so let me invite the second lead speaker in the person of Mr. Edward Alda, who is Vice President of the Hong Kong Maritime Arbitration Group.
Good morning, everybody. Can I have... Chief Justices, senior judges, distinguished officials, distinguished guests, ladies and gentlemen. It's a great pleasure to have been invited to come to Nigeria to share the experiences of another common law jurisdiction, Hong Kong, where I practice and where I'm active in the Hong Kong Maritime Arbitration Group. I saw in the program a reference to pro-arbitration courts in England, UAE and Singapore. I hope I can persuade you to add Hong Kong to that list. For the next program, because as I will demonstrate over the next few minutes, our courts are very pro-arbitration. It's a particular pleasure to be invited to come to Nigeria. It's my first time here because my parents used to live in Nigeria before I was born, and it's always been an ambition of mine to come here. So thank you very much for inviting me. I come across Nigeria in the course of my practice. I'm often involved with ships that are arrested here or Nigerian parties, and I've noticed that Nigeria actually leads the world in two respects, and that is that under the Nigerian Admiralty legislation, there is a right of in rem action for claims for insurance premiums, and importantly, claims to enforce arbitral awards. Nigeria is the only jurisdiction that I'm aware of that has these two heads of in rem jurisdiction, and I think other countries should copy Nigeria's approach. So I'm going to look at these areas over the next few minutes and how they're dealt with in Hong Kong. Stays to arbitration by the courts, anti-suit injunctions, appointment of arbitrators, interim measures including a special Hong Kong mainland agreement, enforcement of awards, and then I'm going to talk about HKIAC and HKMAG. So first, a little bit about Hong Kong. Hong Kong is a fellow common law jurisdiction of Nigeria. It's the only common law jurisdiction in Greater China. It shares a lot in common with Singapore, another common law jurisdiction in Asia. China has one country, two systems approach, where mainland policies are not practiced in Hong Kong. Hong Kong continues to be legally largely independent of mainland China. English law and procedure were introduced 150 years ago, and since 1997, after the return of Hong Kong to China, this has continued very strongly. Hong Kong courts follow case law from other common law jurisdictions, particularly England, Australia, Canada and Singapore, but from judgments from other jurisdictions, for example, BVI and Cayman, can also be cited in the Hong Kong courts. Our courts are conducted in English. All commercial disputes and judgments are available online for free. Hong Kong's top court is the Court of Appeal, which sits as a panel of 5 judges, and we have a unique feature, which is that an overseas judge from another common law jurisdiction sits as part of the panel of 5. Hong Kong is now included in the standard BIMCO Law and Arbitration Clause 1920, along with London, New York, Singapore. So there are now 4 choices that the parties can use or select from under the BIMCO clause. So I need to go backwards, sorry. All right. Just another couple of slides on Hong Kong. So Hong Kong is party to all these international instruments, UNSTRAL model law on arbitration. So unlike England, Hong Kong has directly implemented the model law. New York Convention, of course, for enforcing awards. We have a special arrangement between Hong Kong and mainland China for enforcing arbitral awards on a mutual basis. So this is important for Nigerian parties, often contract with Chinese parties to import goods from Nigeria or export goods from Nigeria to China. And Hong Kong is a suitable choice for your arbitration clause because of the ease of enforcing Hong Kong awards in mainland China. We are party to the 1952 Arrest Convention, like many other common law jurisdictions. A few more success, a strong executive-led support for arbitration. We have a strong up-to-date common law jurisdiction. We have a special admiralty list and arbitration list in our High Court with a dedicated arbitration judge and admiralty judge. For arbitration-related matters that go to court, we have party confidentiality. There are many lawyers, arbitrators, and experts available in Hong Kong. There are many enforcement measures available for award creditors who have obtained awards, such as freezing injunctions and the like. Now, when often parties to a contract which has an arbitration clause will commence proceedings in the court, and the other party will seek a stay. Hong Kong courts have a very pro-arbitration approach in this respect. Under the arbitration ordinance, the court must, not may, must stay the proceedings in favour of arbitration if the defendant demonstrates the existence of an arbitration clause. Now, this is only a prima facie case is required, so if the defendant can show a prima facie argument that a clause exists and applies to the dispute, the court will stay it, and it will leave it to the arbitrators to resolve jurisdictional issues. This is unlike England, where the court can go in more detail into the existence or not of the arbitration clause. So a very light touch approach from the Hong Kong courts. We follow the English decisions of the Fiona Trust, Mozambique and Family Mart. These are leading judgments of the UK Supreme Court and the UK's Privy Council on the proper approach to interpreting arbitration clauses. The courts assume that the parties, as rational business people, want all their disputes resolved by the same forum or tribunal. They interpret clauses widely to cover any dispute or matter within a dispute capable of being resolved by arbitration. So the courts will simply stay all these issues in favour of the arbitration tribunal to decide. Now, where a defendant successfully seeks a stay to arbitration, the court awards indemnity costs against the plaintiff as a matter of course. No need to show special circumstances for the indemnity costs. So on that slide, I've put up some of the authorities. For state to arbitration sought to appeal on the basis that the restriction on appeal was unconstitutional, and the courts rejected that and said that the inability to appeal a stay was consistent with the pro-arbitration approach of, and that restriction was constitutional. In 2023, an arbitration case went to our top court, the Court of Final Appeal. That case involved a multi-tiered clause where the parties were meant to negotiate first. If they couldn't settle, they had to go to mediation, and it was only as a third step that they could go to arbitration. And the defendant attempted to argue that all these matters went to the tribunal, and the court should decide if they were enforceable or not. And our top court said these are all matters of admissibility of the claim, they don't go to jurisdiction, and where a case comes before the court and there is a multi-tiered arbitration clause, and the defendant is complaining that the plaintiff has not gone through all those tiers, that is something for the courts to decide, not, I beg your pardon, for the arbitral tribunal to decide, and not the courts. So the next topic is related to stays to arbitration, and this is the anti-suit injunction, which I think our previous speaker mentioned. Anti-suit injunctions are readily available from the Hong Kong court. So that, I'll give you an example. That is where parties A and B are in dispute. Their contract has a Hong Kong arbitration clause, but B goes off and commences proceedings in a foreign jurisdiction. That would be in the courts rather than arbitration. So in that situation, A can apply to the Hong Kong court to seek an anti-suit injunction and say, even though there are no proceedings, you can proactively go to court and say, look, we have a Hong Kong arbitration clause. Party B has gone off and sued in the courts of another jurisdiction, and the Hong Kong courts will grant an anti-suit to restrain B from proceeding with that litigation, forcing B to come to Hong Kong arbitration as agreed. Again, it's the prima facie case test applies. In my example, Party A would simply need to demonstrate to the court the case that a Hong Kong arbitration clause exists. The court will grant the anti-suit, and the parties must go to the arbitral tribunal, and the tribunal will decide matters of jurisdiction. So again, a very pro-arbitration, light touch approach of the court, always favouring the tribunal over the court as the proper place to dispute matters of jurisdiction. I put some recent authorities on that slide. In Hong Kong, we've had a lot of Russian-related litigation recently. I know other jurisdictions like England and Singapore have dealt with a lot of Russian-related arbitration, and we have recent cases of the courts in Hong Kong granting anti-suits to restrain proceedings in Russia, where the parties have agreed to Hong Kong arbitration. Now, just on the last point on that side, how can the Hong Kong court exercise jurisdiction in my example over Party A and Party B? Well, if Party B, who's commenced litigation abroad, is based in Hong Kong, or incorporated or resident in Hong Kong, the application for the anti-suit can be served in Hong Kong. But if Party B is outside Hong Kong, the Hong Kong application for the anti-suit can be served out of Hong Kong, because the Hong Kong arbitration agreement would be a Hong Kong-related contract. So a very broad jurisdiction. Now moving on to a different topic, this is appointment of arbitrators in default. So we have the typical case of a dispute between A and B, and the contract says any disputes should go to arbitration before 3 arbitrators. Party A appoints the arbitrator, and Party B does nothing. So a default situation by Party B. Now in many jurisdictions, Party A must go to the local court to obtain an appointment of Party B's arbitrator. We have a different approach in Hong Kong. Under our legislation, a private body, the Hong Kong International Commission, is the default appointing body. So in that situation, if Party B ignores Party A and refuses to appoint, you apply just by a simple letter and payment of a fee, and HKIC will appoint Party B's arbitrator for Party B. If there is uncertainty about the number of arbitrators under the clause arbitrator or 3, HKIC can also determine whether the arbitration clause is a one arbitrator or 3 arbitrator clause. So that can be done quickly, no need to get lawyers involved, no need to have evidence, no need to trouble a judge. The private body deals with this. On the second last bullet there, HK MAG, this is Hong Kong Maritime Arbitration Group. You see the logo at the top right of my slide. I'm wearing a HK MAG hat today. This is a body of maritime arbitrators in particular. The HK MAG rules, they follow the LMA very closely. As you have dealt with LMAA arbitration, if the other proceedings, the applicant's arbitrator becomes the sole arbitrator. Very effective, no need to go to court or any other appointing body. And HK MAG rules take the same approach. Moving on to another topic, this is interim measures. So you have a dispute, for example, A and B are parties to a charter party of a ship. There is some sort of dispute between them, say, for example, the seaworthiness of the ship or the conditions under which the cargo is being stored, and say the ship is going to call at Hong Kong, and party B wants an urgent access to the ship to test the cargo or to inspect the ship or something like that. And under our legislation, the courts and the arbitral tribunals can grant a wide range of interim measures. These are orders for inspection of ships or cargo or ships' records. These are orders for preservation of evidence, so not to destroy records, so records of seaworthiness or care for the cargo, for example. And in an extreme case, the courts and the tribunals can order the sale of the property in dispute. For example, if you have a perishable cargo, for example, animal feed or something that is deteriorating during the dispute on board the ship, the court or the arbitral tribunal can order the sale with the funds to be paid into court. Now, the question is, if you are party to a dispute like this, where do you go first, the arbitral tribunal or the court? Well, under our legislation, the court and the tribunal have concurrent jurisdiction. Either the tribunal or the court can measures. If the tribunal is already constituted, you don't apply to the court, or the court will turn you down, and you arbitral tribunal. They can grant a measure, which can then you can go back to court and register it as an order of the court. So very efficient. If you have no arbitral tribunal in place, the court has so in practice, you have a pragmatic calibration. The courts are available for urgent relief, but they will, again, take a light touch approach. If your tribunal is already up and running, the court will not get involved. You go to the arbitral tribunal. So another example of a light touch approach from the courts. All right, enforcement of arbitral awards. I know this is a topic that some of the other speakers have already referred to. So as I said on one of the earlier slides, we are a model law New York Convention jurisdiction. Jurisdiction to force the award debtor to do this determines court, and so parties welcome that as a feature of the English landscape. Now, in Hong Kong, we have a middle ground. Under our legislation, the parties can opt in to a right to appeal to the court. So in your original arbitration agreement, you can select two of the ordinance. If you've done that, then Hong Kong is the same as England. There is a possible avenue of appeal. However, very, very few cases come before the court. Most parties don't opt in, and even those who do, it's quite difficult to get leave to appeal. The Hong Kong MAG terms do adopt this. So if you have an arbitration in Hong Kong under HK MAG terms, there is an opt-in, so you can apply to the court for leave to appeal. So this essentially aligns Hong Kong with London on this topic. Now, in this area, we have had a case recently. A quirk of Hong Kong is that many charter party clauses have a very simple arbitration agreement, and it simply says arbitration in Hong Kong, English law to apply. Extremely short and simple arbitration clause. But it means that a lot of arbitrations that take place in Hong Kong apply English law, not Hong Kong law, and English law is a foreign law in Hong Kong. So the question is, can you, under what I showed you on the previous slide, can you apply for leave to appeal if the arbitral tribunal made a decision of English law, not Hong Kong law? And we've had a case in 2025, again, a pro-arbitration decision interpreting this piece of legislation, and the court agreed that the right to apply for leave to appeal applies if the point is one of Hong Kong law or foreign law, such as English law. So my next topic is challenging arbitral awards. Again, this is a very large topic, as you know. I said a few slides back that Hong Kong is a New York Convention jurisdiction, so you have a very limited right to challenge enforcement or to apply to set aside. There is no, apart from an appeal that I've just discussed, there is no merits challenge to, you can't say, well, the award was not right, that's why I don't want the court to enforce it. If you opt for arbitration, you run a risk that the arbitrators will arrive at the wrong result, but the award is still binding. So the possibility of challenging an award by resisting enforcement or setting aside is extremely limited. Now, what parties often do is they apply to the court and say, don't enforce this award, I said I wasn't given notice, or it's contrary to public policy, or the arbitrator that was not in or failed to deal with the matter that was in the arbitration. So now the courts are very wary of parties applying to set aside the award on these grounds, but really they are bringing a merits appeal, but they are dressing it up as a New York Convention challenge. And the courts are wary of this. Nearly always reject challenges to enforcing awards. I've just cited one case. This is 2026 Hong Kong Court of Appeal, which there are many of these judgments, but this is just a recent example where there was a distribution agreement and a dispute over whether the distributor had met the sales targets or not, and whether the other side had terminated lawfully or not. In short, losing party, there was a distributor. The tribunal found that the company had been correct to terminate the distribution, and the distributor sought to challenge the enforcement of the award and argued that the tribunal had failed to deal with all its arguments. And the Court of Appeal rejected the challenge. The arbitration judge, and on appeal to the Court of Appeal, refused to interfere. And they said in these cases, a tribunal's failure to deal with points must be virtually inescapable to justify interference. All right, thank you. And that brings me to the end of my time. On the last couple of slides, I've just explained the role of Hong Kong MAG, the organization I'm representing here today, and on the following slide, something about the role of Hong Kong International Arbitration Centre, which I've already discussed. So thank you very much. That brings my talk to a conclusion.
Let's put our hands together once again for Mr. Allen. Thank you very much. I will now invite Honorable Justice M.L. Shabu, Presiding Justice of the Court of Appeal, Akure Division, and Honorable, I'll give you 5 minutes. 5 minutes. My Lord, the acting Chief Judge, Chief Justice of Ghana, who is also the chairman of the director, learned presenters, my brother judges, gentlemen. I'm giving 5 minutes, and I think I would even beg for less, because the two presenters have given adequate account of all what is required. Only for me to and give a capstone, my Lord Hassan, capstone of what has been discussed here. We are all agreeable to the fact that Cabo maritime assets are highly. A lot of discuss from the first day to yesterday. We all appreciate the fact that the industry relies on a tripartite dispute resolution, arbitration, and cohesive power of National Admiralty Court. Talking about maritime arbitration, parties choose it for the obvious reason: for speed, confidentiality, and expertise. Courts handle what arbitration cannot. Of course, things like ship arrest, injunction, criminal matters, and enforcement. Admiralty courts in London, New York, Singapore, and in Nigeria play a very key role. They set precedents that shape contract interpretation. Then, on the face of arbitration under the jurisdiction of our local courts, we also need to have hybrid justice delivery, which is a model deliberately linked the two, both the roles of the court as well as the importance of arbitration. The goal is not to replace the court or arbitration, but to use each for what it does best. For instance, our court annexed arbitration with arbitration emergency arbitrators relief, and later goes to court for enforcement. So talking about arbitration generally, the London Maritime Arbitrators Association, the Singapore Chamber of Marine Arbitration, and the China Marine Arbitration Commission continues to dominate the field. The global unity of arbitration rests upon the Convention on Recognition and Enforcement of Foreign Arbitral Awards. The New York Convention has about 172 parties. This ensures that the award issued in London or in Singapore can be directly imposed against bank account or sister vessel in Lagos. The Nigerian position, we have the Arbitration and Mediation Act, which enactment repealed the 2004 regime for maritime dispute. My Lord Taji has given the statutory coordinates. He took them section by section, starting from section 5, which is a replica to what we had in the past. It provides that if someone is sued in the court over a dispute that has an arbitration agreement, the court must stay the case and send parties to arbitration. This application must be made before or at the time of submitting the first statement on the substance of the dispute. However, where the court will not stay if it finds the arbitration agreement null and void or inappropriate or incapable of being performed. This is Nigerian pro-arbitration stance, which we are all advocating for. It prevents parties from forum shopping. Court's role is supervisory, not interventionist. Arbitrators, Section 6 provides that parties are free to determine the number of arbitrators. If they don't, the default is one arbitrator. Most commercial dispute default is one arbitrator for the very obvious reason, to bring down the cost. The arbitral tribunal may rule on its own jurisdiction, including any objection that it does not have jurisdiction or that the arbitration agreement is invalid. A ruling by the tribunal that it has a jurisdiction can be challenged later in court under Section 55, when setting aside the award. The court does not decide jurisdiction first. It keeps arbitration moving, as rightly pointed out, without running to court every time jurisdiction is being challenged. This Section 18, here parties may agree that application for emergency arbitrator relief shall be made to an emergency arbitrator. If parties have not agreed on the arbitral rule that provides for this, a party may apply to court or institution. The appointment shall be made within 2 days. Section 19 is talking about the Federal High Court or State Court may grant interim measures in relation to arbitration proceedings, whether the seat of arbitration is in Nigeria or abroad. These are instances of whatever injunction, arrest of ship, preservation of assets and evidence. This is the big one for maritime. You can arrest a vessel in Lagos waters to secure London-Singapore arbitration. The court's power applies even if the seat is foreign. This morning, my Lord Page also talked too much about Section 12, power of arbitral tribunal to grant interim measures. This provides that unless otherwise agreed, the tribunal may grant interim measures to a party, including security for costs, preservation of assets, evidence, and maintenance of status quo. Tribunal's orders are not self-imposing. You need Section 28 to take them up in court. Recognition and enforcement was also discussed. This provides an interim measure issued by an arbitral tribunal which shall be recognized as binding and enforced upon application to the court, irrespective of the country where it was passed. Tribunal order now have the teeth in Nigeria once the court stamp them. We have grounds for refusing the recognition and enforcement, as well as recognition and enforcement award. There are also Section 15 talking about grounds for refusing recognition and enforcement. All this statutory difference is backed by our superior courts in Nigeria. I cited the case of Mekuye against Emirates Airline, where the court re-emphasized that where parties have chosen arbitration, and we have to respect, must impose it close by staying proceedings. Parties' autonomy is very, very, very paramount. Parties agreed on arbitration, the court should give chance for arbitration. An arbitral tribunal cannot issue an in rem warrant arrest and cannot command admiralty marshal and has no criminal jurisdiction over piracy or oil theft. When talking about the national courts provide the enforcement mechanism that arbitration contract lacks. In Nigeria, as we all know, admiralty jurisdiction is constitutional. I'm referring to Section 251 of our Constitution, of the Constitution of the Federal Republic of Nigeria. The legal statutory framework is the Admiralty Jurisdiction Act, where we have Section 1 that lists 10 categories of maritime claims. Section 3 clothes the Federal High Court with power to arrest vessel, cargo, and freight in rem and to secure maritime claim. Section 7 governs release of arrest of property upon security. The exclusivity was reaffirmed also by our courts in Nigeria. in the case of Allied Energy against Century Energy. We've been talking about Admiralty generally without probably also talking about criminal jurisdiction of our courts in Admiralty matters. The Suppression of Piracy and Other Maritime Offences Act 2019 vests exclusive jurisdiction in the Federal High Court under Section 5 to try piracy, armed robbery at sea, unlawful boarding, and no arbitration clause. I emphasize no arbitration clause can oust this jurisdiction of the Federal High Court in criminal matters. The practice rule in Nigeria arrests in court under Section 3 of AJA and Section 19 of AMA to secure claim, arbitrate the merit under the Administration Mediation Act to resolve dispute. Now talking about hybrid, because neither arbitration nor litigation fully serves the blue economy, global hubs have engineered hybrid. Talking globally, we have SCMA and CMAC. Thank you. I thought I was taking 2 minutes. I would think I would go straight to, cited global practices, London Commercial Court, Singapore, Nigeria, West Africa Operating Adama. Then we also have, talking about hybrid, I have to be a bit selfish. We have also Court of Appeal Alternative Dispute Resolution Rules 2021. I want also give some recommendations. I said to realize this potential of this, Nigerian Maritime and Judiciary must adopt 5 practices. I advocate for strict application of Section 5 of the AMA to impose mandatory stays, no judicial discretion to rescue parties from their contract. Very, very important. The wishes of the party. It is also a proactive enforcement via Section 19. The Federal High Court should build a reputation for rapid, efficient vessel arrest in support of arbitration, irrespective of the seat. There should be clear procedural differentiation. Training counsel to apply to the tribunal under Section 20 for contractual reliefs, and the Federal High Court under Section 19 of the same Act for coercive in-rem reliefs. Finally, there is need for full-scale digitalization because Section 2.4 recognizes electronic. The Federal High Court must expand its e-filing and virtual admiralty docket. In conclusion, arbitration and national courts are not competitors. They are complementary to one another. Arbitration provides flexibility, expertise, and confidentiality. Maritime dispute resolution does not work if arbitration and courts act as rivals. Global practice is moving towards alignment. Arbitration decides the commercial merit quickly and positively. Court provides coercive power and public law. And hybrid tools bridge the gap. The jurisdiction that win future maritime work will be those that make the two work seamlessly. Thank you very much.
Another hand for the speaker. I will invite Honorable Justice Mohammed Danjuma as presiding judge of the Court of Appeal, Abuja Division, and he has my permission to sit and make a comment for not more than 2 minutes.
Chief Justices here present, senior justices from respective jurisdictions that are here, distinguished ladies and gentlemen. I'm here as a participant, first and foremost, ought to have been on the other side listening. But the president of the Court of Appeal sent a word that I should represent her and to serve as a moderator in the session just concluded, or about to be concluded. I came a little bit late, and for certain challenges, I sought for the permission of the moderator, the chairman of session, to speak while seated. Yes, that I've eaten into my 2 minutes, therefore I have 1.5 minutes to go. My simple input into the discussion so far, speaking for the Court of Appeal as a representative, is to observe that at the session yesterday afternoon, the point was made by a speaker that matters in the Court of Appeal could linger on indefinitely for such a protracted time, but for arbitral regulations resort to arbitration, the provision of the Admiralty Jurisdiction Act the rules stipulating how proceedings should be conducted and what should be done. Otherwise, proceedings in the Court of Appeal are always protracted. This, I think, I must debunk. We are not unaware of the fact that the Court of Appeal Nigeria is on top of the game. It's judicial determination. And in this wise, it is cognizant of the premature to hear all cases expeditiously and within a reasonable time and not beyond the statutorily, constitutionally provided period of 90 days for hearing and determination. The Court of Appeal has gone further to provide in its rules, the Court of Appeal Rules 2021, and in the practice directions of 2021, specifically limiting periods for hearing of commercial matters, authority matters, and all other things that border on the economy and the security of the state. Conclusively, therefore, I would say the administration and adjudication of marine matters is a question of the practitioners, including the judges, the Court of Appeal not being an exception, pursuing, taking the benefit of such seminars and workshops as this. This we do. And indeed, we are not unaware that the principle of stare decisis, precedence, must be adhered to. A beautiful decision was referred to by the lead speaker this morning, His Lordship, Honorable Justice Faji. And that is the decision of the Supreme Court of Nigeria by my learned senior brother and my brother from the start. Imagine markets, telecommunications, technicalities, and to go to the essence of the subject matter in adjudication. Finally, I'm sorry, I thank you most sincerely because the nation Nigeria has a policy on alternative dispute resolution. It's a national policy as far back as 20. Also, the Code of Conduct for Judicial Officers, applicable to Nigerian courts, which we must comply with, provides for the pursuit of arbitration, conciliation, all such things that shall promote quick dispensation. And we do know that economic well-being so for the applications of the law, we are above board in the essence of adjudication. The Court of Appeal appreciates it, and that is why I yes.
I think we should continue. Thank you for your observation.
Thank you.
All persons of the Court of Appeal, sorry, of the Supreme Court, hearing that we have been taking through discussions on arbitration. Now we are told that courts have a duty to ensure that disputes are settled expeditiously and amicably. Now, whenever the parties agree to go for arbitration, it is our duty as judges not to assist them to run away from their own agreements. That arbitration contributes to the decongestion of our courts. So it helps us to encourage parties to go for arbitration. And finally, we should be very wary of applications which are introduced post-arbitral award, purposely to frustrate the enforcement of arbitral awards. I think it is time for us to take questions. I will allow for brief questions. Two from male participants and two from female participants. Since we always say that the female first, so I will allow our ladies to female participants to ask their questions. All right. Now, before we take the questions, I will allow our own participants to.
One minute. Well, Justice George Rowe, Presiding Justice, Court of Appeal, Ibadan Division. Thank you for this privilege. Organizers, please, we cannot be backing the slide. We are here, we don't know what's going on. Next time, there should be one for those who will bring up here so that they can see what is going on. My intervention is just a question. How long will African countries go to Hong Kong, to Singapore, to China, to do arbitration? In international arbitration, where are African countries? Where do we stand? And the reason is because we have failed to build strong institutions. We need to have institutions on arbitration that can stem the tide from all of us every time going to Paris, going to London, going to Hong Kong, going to Singapore. And how do we achieve that? That should be the question we should answer in this session. We must find a way to ensure African institutions are confident. People will have confidence in them. And then say, look, rather than going to London, I want to go to Nairobi, I want to go to Abuja to do my resolution of my dispute. And finally, with all deep respect, as a fellow of the Chartered Institute of Administration, I think maritime dispute should more of arbitration, not as an alternative dispute resolution, but rather as a first line of resolution of the dispute. Because the money involved in arbitration in maritime cases, look at it, and then the time. We waste time. But in arbitration, you can be sure these matters can be wrapped up even before the ships begin to get bad and they begin to sell it. So I think we should make arbitration first course of action, and then court alternative dispute resolution in maritime claims. Thank you. God bless you.
Yes. All right. So.
Thank you, my lord.
I thought I gave.
Yes, my lord.
Yes. So let's hear the lady first.
Thank you. Thank you, my lord. Good morning, everybody. My question is, I think, primarily directed to Honorable Justice Faji. My name is Omolola, legal practitioner, Lagos. I want to ask a question as regards, I do know that alternative dispute resolution, particularly arbitration, is a party-agreed mode of dispute resolution. So my question is this: goes to court in breach of that clause, and the defendant does not object, and the matter goes through plenary trial. Is the court at liberty, instead of giving judgment, to now refer the parties to arbitration?
All right, your question will be answered.
Yes.
Thank you very much, the Chairman, the Lords. I'm Justice Phoebe Anua of the Federal High Court. My question relates to the principle of competence. Under that principle, the panel competent to whether it has jurisdiction to try that dispute. But then my question is, sometimes when the arbitration panel decides that it has jurisdiction, one of the parties want to run to the court to challenge that decision of the arbitration panel, insisting that the arbitration panel does not have the competence to try that dispute. So, in such a case, what happens? The principle is competence. Should it be the last port of call, or should any of the parties have the leverage to also go to appeal that decision? Thank you.
Thank you for the question. The next. Yes.
All right. I observe all protocols. I have two short questions. The question number one goes to Honorable Justice Faji. The Lord did mention that you don't need an app.
Please,
My name is Angus Obinna Chukwuka, legal practitioner in Port Harcourt. Yes, my Lord.
yes.
So the question is this. The Lord said that you don't need an application to recognize an arbitral award. And I want to understand, is it because it will cause bureaucratic bottlenecks to do so? Or are you saying that it will be unlawful or illegal to do so? Then second question is,
answer that is a patriotic piece of legislation meant to grow the maritime industry in Nigeria, notwithstanding the inelegance in drafting. And but from what you have said, the witness case, the Supreme Court defeated the wording of that act, but did not. That act, section 2 is the law, if I'm understanding correctly. That is the law as of today. How long will it take to have it amended since there is inelegance in drafting? But if it is the law and it is patriotic, then why don't you apply it and stop complaining? Thank you very much.
Good morning, everyone. I have a question for, my name is Nigerian from my private school in Lagos. I have a question for Edward Calder. You mentioned in your presentation that Hong Kong, the China has two countries, two law policy. How does that really help? How has that affected adjudication for maritime cases in Hong Kong? I'd like to know that first of all. And secondly, what is the policy of your maritime to disseminating arbitral awards? I ask that because whilst arbitration is confidential and as regards to the requirements of Nigerian maritime arbitration, how would you recommend we help disseminate the facts while still putting the level of confidentiality on so that people can learn more? Thank you.
All right. Please, can you mention your name once again if you are? Thank you. All right, so I will now invite the All right, you want to respond to it? Yes. To respond to the question.
Thank you for the question. Yes, so on the first question, Hong Kong and China operate for day-to-day legal issues completely separately. So Hong Kong continues as a common law jurisdiction, and issues such as state arbitration, or all arbitration policy is dealt with completely by the Hong Kong courts. And we have our own legislature, the Legislative Council, which passes arbitration laws and reviews arbitration laws. So there's really no connection between the two jurisdictions for day-to-day arbitration matters. The one link is, I said on one of my slides, is that before 1997, the New York Convention actually applied between Hong Kong and China because they were regarded as separate states. Now, Hong Kong and China unified in 1997. So New York Convention could not apply within a country. So we have a special arrangement called the mutual enforcement. So awards, mainland awards are enforceable in China, Hong Kong awards are enforceable Hong Kong awards enforceable in China, mainland awards enforceable in Hong Kong. Very similar to New York Convention. So day-to-day, mainland China really has no effect. That's why Hong Kong serves as a neutral location. If you have a Chinese party and say a Nigerian party, they will, like Singapore, they will often choose Hong Kong or Singapore as a neutral venue. So even though we are within China, we're regarded as neutral. So on your second question about publication of awards, so this is not really strong in Hong Kong. We don't have a strong tradition of publishing awards. Awards are confidential. I think all I could say on that is you probably know that from the Lloyd's Maritime newsletter often publishes anonymized awards, mainly English awards, of course. It's an English publication. So they will publish anonymized summaries of LMAA awards. Now, occasionally, Hong Kong awards can feature in that publication on an anonymized basis. But apart from that, I'm not really aware of any other outlet by which Hong Kong awards are made public. Yeah, there's complete anonymity. And if you have proceedings in the court, so you are challenging an award or you're staying, etc., the judgments will just say A against B. They don't disclose the parties. So there's even confidentiality in the court. Thank you very much.
Thank you very much, Lord. Thank those who have directed questions to me. I'll start with Mrs. Ikwagu. Section 5 of the AMA states, notwithstanding provision of any other law, a court before which an action is brought in a matter which is the subject of an arbitration agreement shall, if any of the parties request, not later than when submitting their first statement on the substance of the dispute, refer the parties to arbitration unless it finds that the agreement is void, inoperative, or incapable of being performed. What this means is that if you do not raise the issue of arbitration upon your first statement, you have conceded to the jurisdiction of the court. So, I mean, and the court will not have the powers in its final judgment to say, I'm divesting myself of jurisdiction. So that is, I think, the simple answer to that question. Justice Ayua, the principle of competence. Of course, the tribunal can decide its own jurisdiction, but Section 14 says that the tribunal should, as much as possible, in determining its jurisdiction, also try and take the substantive matter along with that. But at the end of the day, you have a holistic ruling and a holistic challenge to the award and to avoid delay. Now, the principle in challenging the jurisdiction of an arbitral tribunal is different from the principles in courts. You can raise the issue of jurisdiction at any point in time in the courts, even if it was not raised at the lower court. But in arbitration, the issue must have been raised at the arbitration and determined at the arbitration. The arbitrator must be given the power to determine his own competence at that point in time. So if you don't raise it at the tribunal, then you cannot raise it in court. So, and that's the, yes. So you cannot challenge the decision of the tribunal unless it has been raised before the tribunal. Angus, it's been a while since I saw you last, maybe 100 years ago when I was in Port Harcourt. Now, you spoke about recognition. I made the point in the presentation because it's something that appears to be something that lawyers tend to do, which is not necessary. Now, Section 57 says, an arbitral award shall, irrespective of the country or state in which it is made, be recognized as binding. So it's recognized as binding because that was the agreement. The agreement was that you would resort to arbitration and that any decision reached by the arbitrator is binding on the parties. It's based on factors of suit surrender. Now, so it's recognized as binding. Now, the section now goes on to say, and on application in writing to the court be enforced. So you don't need a court order to recognize it as binding. You yourselves, both parties to the arbitration, have recognized it as binding. You have agreed that it shall be binding. So you can now, but because you need the powers of the court post-award to give effect to the award, then you must then come to court and make an application to enforce the award. I mean, if you recognize it as binding, you have a duty to obey it. But if one of the parties now decides that, no, I'm not going to obey this, then the other side will go to court to enforce it. Section 20 of the AJA, Justice White spoke about it, working on its head, not properly thought out. Shouldn't be, and of course, Justice White will recognize the absurd consequences of what Section 20 would lead to. I agree that the AJA was a piece of legislation that was done to protect our interests as a cargo nation. But then, of course, in the course of making that legislation, there was a confusion as regards foreign jurisdiction clauses, as regards court cases and foreign arbitration clauses. And that is what is now playing out, unfortunately. Then you said that how long will it take to have it amended? I don't know. 1991? It's a matter for the legislation. But we are assured that if you have things in the National Assembly, there are groups that will ensure that the legislative action is taken. I don't know about why campaign, but then we can only say what we see. Thank you.
Thank you, too. Well, I think the only intervention I can make is with regard to the suggestion pointed out by my late Judge Willie, that we should de-emphasize going to court in maritime matters and stick to arbitration. I think the simple answer is that almost all maritime contract contains arbitration clause, so which emphasize the importance of arbitration over going to court. But there are, as I said in my course of presentation, there are areas that arbitration could not do. Only court can provide the punitive part. Arbitration cannot arrest ship and so many other things. But I assure you, my lord, that arbitration play a pivotal and role in dispute resolution in relation to maritime and matters. Thank you very much.
Right, so finally, I think we have come to the end of our morning session, and I thank all of you for the enthusiasm which you have shown and for the participation. Now, let me just say a word about what the Honorable Judge will, the place of arbitration. Now, you recognize that normally these arbitration clauses are contained in agreements. And so it is our duty as judges to encourage our businessmen to also insist on having the arbitration within the continent. I think once we do that and once they buy into it, we wouldn't have to go to Hong Kong, we wouldn't have to go to London and other places. Thank all of you for your participation and for your contribution also. Thank you.
Thank you very much, my Lord. Please, can I request that we please all give them a very deserving round of applause. We appreciate you, the Executive Secretary and CEO, Shapers Council, Dr. Akuta, Pius Kayime, please, MON, PhD, please join us as we also invite the Chief Justices of the various countries that are here and their representatives to please join them for a photo opportunity. And after which will be, first of all, whilst they're even coming, we must also bear in mind that today is Friday and there's half day. Brothers and sisters of the Muslim extraction would like to go to for Jummah prayers. And we need to put this for a voice, to a voice vote. Would you rather prefer that we continue as against going for the health and tea break, that we just continue and round up at a time when people can go for prayers, and when we come back and lunchtime and we're dispersed from there afterwards, because we also have the communique to be presented before all that happens. Those in favor that we continue say aye. Those against say nay. I'm not getting a nay, so do I say that the ayes have it? Is it your opinion that we continue as against going for the tea break? We should go for the tea break. Okay, those in favor that we go for tea break say aye. Those against say nay. I want to be very democratic. I think the nays have it. Do we agree with that? So we can continue as against going for tea break. Okay, we'll take the tea break afterwards then. Of course, to enable our brothers and sisters to go for the Jummah prayers as well. And knowing that today is half day, this program comes to an end today. And we're also aware that quite a good number of us would like to fly back to our respective destinations, those who are leaving today. So please, kindly tarry with us a while as we continue from here. Thank you very much, my Lord, the Justice of the Supreme Court of Ghana, who is standing in for the Chief Justice of Ghana. Thank you so very much. We appreciate your contributions from Hong Kong. Thank you, and thank you very much indeed. Having done this, would like to quickly move in straight to the next session. This was found on a table and was brought to us. If you've misplaced yours, it is a book, International Trade and Carriage of Goods by Sea, Texts, Cases and Materials, authored by Mfon Ekong Usoro. If it is yours, please call me and I'll bring it to you afterwards. Thank you very much. So we move on quickly to the next. We'd like to move in straight to the afternoon session, as it were, as we invite the persons who are meant to be superintending over this last session for us very quickly, without much ado. Thank you very much. Appreciate it. My Lords, the Chief Justices, my Lords, Honorable Justices of the Supreme Court, Honorable Justices of the Appeal, Federal High Court, and heads of other courts, distinguished Leonard Silks here, Executive Secretary, our host, very distinguished ladies and gentlemen. Aligning Nigerian maritime dispute resolution is what we just trashed, and so now we're going to be looking at the demurrage, detention and storage charges, legal characterization, risk allocation, and global best practices. To take us through this, would like to invite very quickly the lead speaker to come take a seat, Dr. Emeka Akabo, Senior Advocate of Nigeria, Senior Partner Akabogo and Associates. If he's here with us, can we please welcome him over? Plus, he's making his way here whilst he's coming. Our panelists, Chief Oswala E. Wagbara, Principal Partner Maritime and Commercial Law Partners. Can we please welcome him as well to take his place? Chief Oswala. Thank you. Please a round of applause for him. Mr. Edmund Sasu is the Head of Customer Experience, Mask Nigeria Limited. Mr. Edmund Sasu, can we please have you join us here, sir? Please a round of applause for him as he makes his way here.
The fourth person we're inviting over as a panelist will be President of Association of Nigerian Licensed Customs Agents. Is the President here with us? Okay, I've just been told that Edmund is unavoidably absent, but Adekunle is here sitting in for him. Please can we give him a round of applause? That is deserving as well, please. Thank you very much. And at this point in time, we'll be inviting the person who will be superintending over this session for us. Edmund Sasu is represented by Mr. Adekunle Afikode, Customer Experience Manager, GMCG and Relief Cargo. And of course, Mr. Emenike Nwokeji, President Association of Nigerian Licensed Customs. He's already here. Please a round of applause for him as well. Thank you so very much. And so you'll be moderating the session. Is that what it is? Can we get the name of the moderator of this session, please, very quickly? We're actually supposed to have Justice of the Supreme Court handle this aspect for us. But if we get the organizers to quickly give us a name, can help us facilitate this session and moderate, we're very glad. It's Barrister Emeka anywhere close by, or any of the members of the organizing committee can just assist us with that very quickly, so we can move on with the speed that is deserving of a program of this nature, especially on a Friday. Do we have a replacement? The honors is now on our very senior judge, Honorable Justice Ibrahim Buba, retired, please, of the Federal High Court, to help us facilitate this. Please can we welcome him with a resounding applause as he makes his way to the stage to join them. And being a judge, very many years of experience, and one that is highly respected, one with great intellect, is a man of many parts. I'm told even during when he served, they call him a mobile encyclopedia in law. So please can you welcome with me one more time the Lord Honorable Justice Ibrahim Buba, retired. Thank you very much, sir. You have the microphone and your time starts now. Thank you very much, my Lord.
Good morning, my lords. Let me rest on the existing protocol. I was trying to point at Justice Danjuma, who will be representing the President of the Court of Appeal, and the question and answers, who just left the podium, but I think they mistook me that answer. So, form, thank you. It's the labor I glad. Let me quickly, time is fast spent, and you said it's a half day. I don't believe in protocols. Dr. Emeka, let me not the other name, SN. It's not only well known in the Maritime Committee. It's my very good friend. He has appeared severally before me, but I'll proudly tell you, when I went for the ship detention regulation in Southampton, he was the one nominated to go with us. Since then, we struck a relationship. I always refer to him anytime I have problems in Maritime. He's always one of them. When he got the silk, I was very happy. So if I'm moderating your session, I know exactly what you can do. Chief Wabara is also one of them. They've appeared severally before me in Lagos Division on Policy Matters. In fact, in one of the cases, Funke Agboye said, we just left for Sebuba, what is the policy decision? I said, I don't want Cotonou to be better than Lagos. So you have powerful people around, and for those of you who I do not know very well, don't be jealous, you have an opportunity. Please, Dr. Akabogo, take the floor quickly. And I don't know how many minutes I should give you, but I will be looking at my watch. And I know it's difficult to stop you when you start talking. Please, take a second.
Good morning, my lords. May I take the permission of the chairman of the session to stand on all protocols which have already been established in the course of this event. Please could my slides be put on the screen. Our discussion this morning is on detention and storage charges in the ports, legal characterization, risk allocation, and global best practices. So that's the subject of our discussion this morning. And this discussion is essentially an extension of the discussions which we've had in the course of the last 2 days, particularly relating to cargo claims in the course of maritime transactions. The presentation this morning would traverse the basis for this topic, then key concepts and definitions which we'll be dealing with. Then we will try to focus on the problem, and then a legal analysis of the issues which attend that problem, risk allocation, and then very important, a very important part of our presentation will be recommendations which we'll be making. Now, I won't belabor the facts. It has been mentioned here severally that the maritime industry and carriage of goods by sea is a crucial component of the economic destiny of Nigeria. So I wouldn't belabor that fact, and I'll skip it and go straight into the question of why the discussion of today is important. The discussion of today is dwelling on demurrage, detention, and storage charges. In the course of clearance at the ports, demurrage, detention, and storage charges regularly arise. However, an important background to this subject is to have an understanding of the process for cargo clearance, and the implications of this process will become evident in the course of our discussions. So you will find that in a typical situation where goods are imported into the country, the process starts sometimes even before the arrival of the goods into the country, where the importer, through his agents or directly, liaises with regulatory organizations towards ensuring that pre-arrival processes are in place, which include the submission of manifests, import documents, opening of Form M, and the pre-arrival assessment reports processing. These documentary requirements are crucial because they become relevant in the course of clearance by customs. When the vessel arrives at the port, the cargo is discharged from the vessel, and the discharge of the cargo from the vessel leads to the cargo transiting from the vessel onto the terminal. When it's from the terminal, it is stacked at the appropriate place at that point in time. So you see a transition of the cargo from the carrier, from the direct possession of the carrier into the possession of into the custody of the terminal operator. So this happens upon arrival of the vessel. While the cargo is within the port environment and has been stacked, the customs has to undertake an inspection. The regulatory formalities relating to the clearance include customs inspection. Typically, you have a joint inspection which involves the customs, involves other agencies of government that are involved in formalities, such as the Standards Organization of Nigeria, the drug enforcement agencies, the quarantine, in some cases the security agencies, and the Office of the National Security Advisor. Then, if everything is okay with the cargo, it will be released by the shipping company. Don't forget the shipping company is represented, the carrier, international carrier that's brought the vessel, most of the time is represented in the country by a local shipping company. Many times the international companies establish local companies that are agents to the carriers. It is these agents that facilitate the release of the cargo to the custody of the cargo owner, whether it's a consignee or other relevant cargo interests. But typically, the release of this container by the shipping company does not necessarily automatically imply that the cargo is immediately ready to leave. Because you may have a shipping company release, but the cargo may still be subject in one way or another to some formalities, and it may still be subject to compliances with the terminal. But it's until the terminal issues a terminal delivery order that the cargo is able to move out of the port, outside the gates, and into towards the warehouse where it's proceeding. Now, the importance of these stages of the process lies in the fact that in any stage of this process, there may be events which occur. And that will take us very quickly to the primary definitions of the subjects that we're dealing with. So, the first is demurrage. And in defining demurrage, it's important, even though it's not the subject of our discussion today, but because we're dealing with the Maritime seminar, I'll equally mention the relevance of demurrage within the context of a voyage by a vessel, which is not what we're discussing, but we need to distinguish it from cargo demurrage, which is the subject of our discussion. So if we're dealing with demurrage when you have a voyage charter, that typically refers to a situation where the vessel, which had cargo within a port environment, is under charter, and under the terms of that charter, the charterer has a time within which it is allowed to discharge the cargo. Beyond the time within which it is allowed to discharge the cargo, the vessel starts charging demurrage to ensure that the vessel gets value for the time it is spending beyond the time that was contemplated originally. So that's demurrage within the context of a voyage charter. However, the demurrage we're speaking about is demurrage within the context in a container which is within the port. So cargo demurrage generally refers to the time which the penalty or payments which accrue to the shipping company with regards to the continued use of the container beyond the free period that is allowed within the port. So the cargo is discharged, as you noted in my earlier description of the stages. The cargo is discharged from the vessel onto the terminal. The shipping company allows a certain number of free days between the time of that discharge and the time the demurrage actually starts counting. So that period, after the exhaustion of that period, demurrage starts counting. The purpose of instance, the legal basis of this demurrage which is charged is found in the bill of contract between the consignee or the importer and the shipping company or the carrier. The second, the primary issue here is that demurrage is chargeable with regard to time when the container is located within the port. The second concept is that of detention, container detention. We're still speaking about the same container, but this time we've gone beyond demurrage into detention. And detention is charged with regard to the extended use of the container or the non-return of the container after the container has left the port. So the container leaves the port after it's released and is supposed to be returned. Don't forget that the container is equipment which is owned by the carrier, and the container is to be used by other consignees as part of the assets of the carrier. So it's supposed to be returned within a precise time which has been stated in the terms of the parties. So non-return of the container within that time opens the consignee or the cargo interest to detention charges. Then of course the last is the storage charges, which essentially refers to the charges which accrue in favor of the terminal operator with regard to the occupation of the space of the terminal by the cargo interest. Don't forget that the terminal operator gets its profits from leasing the space at its terminal to various users of the space, including persons who have their containers stored. So the basis of the container detention, again, is a bill of lading or the other documents of contract. The legal basis for the storage charge typically will be bailments or other statutory components. Now, what exactly is the problem? The problem for which we're having this discussion is that, having defined what we've defined, I must say that whether it's demurrage, detention, or storage, these concepts are concepts relating to charges and accrued penalties which are valid on their own. So we will not, there's no problem ordinarily with any of these charges, because they are charges which parties in the where the relevant circumstances apply, then they should be liable for. However, the big problem with the characterization of these charges and the definition of, and the correct definition of when these charges actually validly accrue. So, carriers, we've said that there's a basis, and the basis, one of the bases which we've identified is contracts. So, with regard to demurrage, the bill of lading is the contract which puts the terms, which sets out the terms upon which parties are engaging. Now, that bill of lading, typically, it's important to note that the bill of lading is a contract which is issued by the carrier to the consignee. Most of the time is a contract which the consignee is not party to its making. He's bound by the bill of lading, but is really not party to the making. The bill of lading, at the same time, because it is a formal contract, it has standard terms, boilerplate contracts, which have terms that are generally regarded as terms of adhesion, which is terms which the other party is bound by the fact that even though he has not contributed to the making of those terms. So obviously one party is in a stronger position than, and to that extent that is in the weaker position is subject to be occasionally unfair, if I may put it in that way. The challenge is the cargo interest sometimes may find himself being levied with charges arising from circumstances that he has absolutely no control over. That's where the problem is, and that's where the claims which come before the courts and the problems which are complained of by these cargo interests arise from. Where there is a right, yes, there should be a remedy, but where there is no breach by a party, or the party has to face the consequences of the other party suffering loss, that's where arises. From the point of view of the... So I'd like to go very quickly into the characterization which we have identified. So we've identified the challenge which is faced cargo interest as being one where he is faced with charges that he has no control over, that he has not caused. most of the time, when you have these matters coming before the court, because the cargo interests have been levied charges, and don't forget that by virtue of the power of lien of the terminal, for instance, and even of the shipping company, the power of lien which they have ensures that irrespective of a complaint or a rejection of the charges by the consignee, such a consignee has no power under the circumstances to do anything with regard to movement of its cargo until it is released by the shipping line or until it is released by the terminal operator. So the cargo interest must, in the circumstances, deal with the circumstances which attend such. Now, there are three anchors on which these issues arise and on which these issues have to be analyzed. The first is contract, and the second is bailment, which are the primary anchors of these charges. A third supporting anchor, I will call it a countermeasure, and that is statute and regulation. So let's go first into contracts. So the contractual framework of the Bill of Lading, we've mentioned contract, but we want to dive a bit deeper into the text of these contracts. The Bill of Lading. The Bill of Lading will typically have terms which define the concepts of demurrage. What we've used for my paper, which I'm sure the organizers will share, is the standard Bill of Lading of CMA CGM. But most of the shipping lines have similar provisions. In some cases, the provisions are actually almost identical. So I'll just touch on a couple of these terms just to give us some kind of illustration into what we are talking about. For instance, freight. If you look at the definition of freight within the Bill of Lading, many times you see that the freight, in defining freight will encompass demurrage, detention, and third-party charges. Even though ordinarily the definition of freight relates to the cost or the charge which is levied by the shipping company or the carrier for the carriage of the cargo from one point to another. That's what freight is ordinarily. But within the Bill of Lading, it incorporates other charges which include demurrage, detention, and third-party charges. Now, it finds the terms and conditions of the carrier's applicable tariff typically incorporated in that Bill of Lading. So on the face of the Bill of Lading, see any reference to specific charges. You may find these charges on websites or upon request from the shipping companies, but you won't see them specifically itemized on the face of the Bill of Lading. What it incorporates these charges wherever it may be found. The reality which you face with that situation is that it often incorporates external unattached rules regarding container or vehicle demurrage, which means that at the point in time the consignee gets bound to this Bill of Lading, he's getting bound to terms that he may not even know the final implications of. A second important clause, which you'll find in clause 6, 11 and 26 of the Bill of Lading for CMA-CGM, is responsible for returning any empty container at a designated place. But of course, again, this presupposes that in returning the empty container, the designated place is available and free. Then finally, another important clause is clause 13, which is the lien clause. And this clause grants a carrier a lien over the goods for demurrage, for detention, and for storage. The implication of this is that the shipping company will not release the cargo, and typically will not release the cargo until a debit note which is issued with regard to a demurrage charge is paid. It doesn't matter that the debit note is considered to be wrongfully issued or even illegal by the consignee. It must be paid before it is released. So that's grounded on the lien clause in the Bill of Lading. But again, from a legal point of view, it has equally been decided by the courts, by the Supreme Court, that a lien is a means of securing a provable debt and not the substitute for proving that debt. And we'll go into this characterization in a bit more detail in construction of these issues. So, in reviewing some of these terms, the question will now be how to approach the analysis of the terms of the bill of lading, which, as I've said, is a contract of adhesion when dealing with very practical circumstances. It has been mentioned in the course of this morning's, the first session, I think Honorable Justice Shaibu mentioned it, that, look, parties are free when they're entering into contracts. So they're entering into contracts freely, and they must be bound by the contracts that they enter into. So to that extent, yes, the bill of lading is binding on the consignee and the parties associated with the bill of lading. But then, it has been decided, so of course, in my paper, which is my longer paper, we'll see the case of Nika Fishing, where the court indeed held that parties are bound to what they've contracted to the bill of lading. But nonetheless, there is and should be a countermeasure. And the countermeasure, again, is found in the approach for dealing with such contracts. So the contract preferentum principle, which requires that when there's ambiguity in the framing of a contract, particularly a contract where the weight and the strength of the parties is uneven, then parties and the court should construe this contract very, very strictly against the interest of the party that is purporting to rely on the contract. But another important judicial countermeasure in statutes, and I'll use this opportunity to quickly make reference to two important provisions, statutory provisions in the legal regimes that Nigeria is bound to. In the Carriage of Goods by Sea Act, which essentially mirrors which is a document that brings in the Hague Rules into application within the country. Article 3, Rule 8 provides of the Hague Rules, it says that any clause, covenant, agreement, any clause, covenant, or agreement in the contract of carriage or the ship from liability for loss or damage, for loss or damage to, or in connection with goods arising from negligence, fault, or failure in the duties and obligations provided in this article, or lessening such a liability otherwise than as provided in these rules, shall be null and void. So this provision in the Hague Rules mandates that provisions in the bill of lading of the nature that exclude liability in one way or another will be void and of no effect. Another important provision is in Article 5 of the Hamburg Rules, which operates in Nigeria as the United Nations Convention on the Carriage of Goods by Sea Ratification and Enforcement Act. Now, this provision that the carrier is liable for loss resulting from loss of or damage to the goods, as well as from delay in delivery, if the occurrence which has caused the loss, damage, or delay took place while the goods were in his charge, as defined in Article 4. So provided it happened within his custody, then he will be liable. Unless, of course, that carrier proves that he, his servant or agent, took all measures that could reasonably be required to avoid the consequences of that occurrence. Now, these provisions are important to the extent that they provide a countermeasure to the provisions in the bill of lading which impacts negatively. Now, I'd have to very quickly run through the other anchors of my presentation, given that I've been told I have only 5 minutes to go. Bailments. The possession of the terminal operator is on the basis of bailments. The cargo owner has no relationship, no contractual relationship with the terminal operator, but the terminal operator nonetheless is able to levy charges against the consignee before the consignee takes goods, because there's a relationship of bailment which is deemed to have been to have come in place. I won't dwell on that in detail because I want to really skip quickly to judicial guardrails. I also won't dwell on this. The only point I'll make here is that the Nigerian Customs Service Act of 2023 has provisions by which the terminal operator or the shipping company may, after a certain number of days where the cargo remains in the port, has applied to have these goods moved from the port to an area, a warehouse area where the customs may take custody of the goods. And this provision is important to the extent that it gives the terminal operator the right to mitigate the losses he may suffer and not have to impose those losses on the consignee. Now, again, a very important countermeasure are the regulatory provisions which are in place in favor of the shippers, and these will be found in the Nigerian Shippers Council Act and the Nigerian Nigerian Economic Regulator Orders of 2015. First of all, the Nigerian Shippers Council Act sets out the charges, which sets out the power of the Shippers Council to approve charges which consignees will be subject to. Typically and historically, you've had situations where shipping companies and terminal operators have a range of charges, and sometimes some of these charges are not charges which have been approved. And it is such a situation that led to the case, my lord, which you recall in 2014, where terminal operators and shipping companies had their had charges which they had levied struck out. Which today they've had significant damages awarded against them in respect of. So I'd like not to dwell on this, but just to point out that these provisions of the law equally act as a countermeasure against the weight which is of lading. Now, very quickly before I go to my recommendations, and my recommendations are very important. I've set out a responsibility matrix in regard to this. So the matrix sets out the drivers of delay and then the legal consequences. So typically you see a driver of delay could be the cargo interest. In that case, yes, the cargo interest should be responsible where he's responsible for the delay. However, where the carrier terminal causes the delay, that delay should not have the consignee paying for the delay caused by the carrier or the terminal. Yet this happens regularly. Typically, all the terminal or the carrier will typically do is calculate the number of days that's passed, provided it's gone beyond the agreed 3 days, they levy the charge without reference to what has caused the delay. So particularly where the carrier or the terminal is at fault, they have to bear such a charge. Then the other is the public authority, delays caused by public authorities, whether it's a customs or other statutory restraints. In this instance, again, the responsibility matrix that I'm proposing is a review, waiver, or statutory adjustment. There's a lot more interrogation that needs to go into this because at the end of the day, the terminals, the shipping companies, they're businessmen, they're there for business, and what should give them profit and they're paying for, as ably articulated by APMT, Chinyere from APMT yesterday, there must be a remedy one way or another. But the point we're making is that the remedy should not be the consignee who is an innocent party. So further interrogation needs to go there. And then of course, where there's concurrent delay. I've done some research into global best practice on this point. And what stands out for me, particularly in the United States, is that the delay which has been occasioned by the carrier or even by a regulatory compliance issue that is not the fault of the consignee or cargo interest must not be placed on that consignee or cargo interest. And that is incorporated in their FMC rulings of 2024. So statutorily, it is there in place in the United States, and I think it's one of the things that we need to look to. An important other component is that in Singapore, which has a very detailed information technology-driven system to ensure that it is able to identify where what has happened at every point in time. Now, I'm going very quickly to my recommendations, and that's where I'll end. Now, my recommendations stem from what I feel constitute the mischief that is leading to this situation. An important part of this mischief is that there is a difficulty of achieving visibility on a stage-to-stage basis of where the issue that triggers the delay occurs. If the issue that triggers the delay is visible, identifiable, trackable, and easily harnessable, then it solves problems for all parties. Because visibility trumps opacity. And to that extent, visibility will even put the terminal operators and the shipping companies on their toes with regard to making debit notes which are illegal. Chinyere spoke yesterday and spoke about terminal operating system, which gives visibility of what the tracking of the cargo is at every point in time. The challenge with that is that it's a terminal operating system which is exclusively within the control of the terminal and which is not visible to other parties. And when you bring a claim against a terminal operator, typically the terminal operator will not give you visibility of that, what is happening, particularly if it is against them, including when it is against the shipping companies. Because you have many situations where, in fact, terminal operators have a standard operating agreement, a service level agreement with the shipping companies. And at the least, where a cargo interest has raised a complaint relating to the validity of a charge, and it is evident that the charge and the delay which is accruing has accrued from the point of view of the shipping company, it is expected that the terminal, having visibility of this, should be able to put it forward. But typically it doesn't do that. And the simple and easy recourse is to levy the charge on the cargo owner. So my suggestion, one of my primary suggestions, is that there should be a logistics single window. Now, the federal government of Nigeria is instituting a national single window, but that is essentially a formalities single window that aggregates the operations of all the agencies that are involved in the formalities process, which is good. But what is important within this context is a logistics single window, and to be available and to be used, operable by all the parties, the carrier, the terminal operator, the consignees, the stevedores, all the parties involved in that process. It ensures that every submission goes through that single window. Every application goes through that single window. It ensures visibility. The terminal operating system of the terminal needs to be logged into that logistics single window. That of the shipping company equally needs to be logged into it. And it gives that visibility, which is important. Of course, uniform invoicing standards are very important. Uniform invoicing standards to the extent that you have in the United States, where it has been set out in the law what the format of the invoice should be. So if you are levying a charge, the source of the charge should be clear. The timing when the charge started accruing should be clear. And the particular parties for whom the charge is directed and who could be involved in the charge. That way, the visibility of operational triggers, which I've mentioned, can be evident even from the point of view of the invoice. Then, of course, the statutory stop-the-clock events. So, what events are there that will stop the running of the clock of demurrage, or the running of the clock of accrual against one party as against the other? Then, of course, mandatory mitigation duties. I've made reference to provisions in the Nigerian Customs Service Act, which they don't impose an obligation, but they advise that, and they leave a window for terminal operators and shipping companies to mitigate the losses that they suffer that they typically want to push to the consignee. Then, of course, finally, the provisions of the container insurance reform, which we find in the Nigerian Insurance Industry Reform Act of 2025. In conclusion, my lords, I think that the adoption of the recommendations which I've set out would be important. Let me just read it because I think it's better, it's fully taken in its context. Demurrage, detention and storage charges remain necessary to the orderly use of port space, custody facilities and container equipment. Their legitimacy, however, depends on more than the existence of an invoice or the passage of time. A recoverable charge must be anchored in contracts, tariff, statute or regulation, triggered by a proven operational event, computed transparently, and allocated to the party legally responsible for the delay. Contract supplies the initial bargain, bailment imposes reciprocal duties of custody and delivery, and the statutory framework subjects ports charging to jurisdictional, regulatory, customs, evidential, and public interest controls. The decisive judicial task, therefore, is to reconstruct the operational chronology and distinguish the accrual of charges from their final allocation. Beyond the adjudication, the more durable solution lies in prevention through visibility. A logistic single window, supported by reliable time-stamped records, will reveal the true trigger and duration of delay, promote fair billing, strengthen regulatory supervision, and provide dependable evidence for dispute resolution. Combined with uniform invoices, stop the clock rules, mandatory mitigation, prompt dispute resolution, and effective container insurance, this framework will protect legitimate commercial recovery while preventing systemic or third-party failures from being unfairly converted into charges against the cargo interests. Thank you very much, my lords, for listening.
My lords, even though we have adjusted time, I am pained stopping Dr. Akabogo. Honestly speaking, when you gave us the paper for our feedback, even though it's anonymous, if you see anybody complaining about the timing of this paper on Friday, this time I'm the one. Because everything I said, excellent, 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 strongly accept that. Because this topic they are talking is very, very important. For my brothers, Muslim brothers, we'll give one to Caesar what belongs to them, but we'll give God one. National mosque worship at 2. So we will claim my indulgence if I just give you five minutes. You should understand. This is one area, if I knew I was going to chair, I have a lot to say. Dr. Akabogo, Chief Wabara, they were all involved in the Apapa Terminal against Shippers Council. They are also involved in Orient and Shippers Council, and I was the judge. I also know so many containers that went into demurrage. I know one that they gave a check in Canada, it turned out to be dog check. Before the containers arrived, they rushed to Port Harcourt, they arrested them. All those things, my container, you borrow money from the bank, you go to bank, get all the money, and then the container inside is demurrage and it's auctioned. I left Lagos with those cases later, and this is not a matter we should just treat on the surface because of one of time. Peter Abrams in Mind Boy said, women always spoil a good fight. In legal argument, time always spoil it for you. Please bear with me. 5 minutes, 5 minutes, 5 minutes. I won't say anything more. I'm already done. We'll have 15 minutes. So that by one, those of us who go to national mosque, it's not about going there on time. There's a particular hour. Once you enter there, it's time for God. It's no longer your own. I'm conscious of Surah to Juma. So my Muslim brothers, bear with us. And even if we are going to come back probably before they communicate, issues are in this area of the law. Very, very important. Please. I didn't want to stop it, but I will put the hammer. I will be. Thank you very much.
My Lord Justice Buba, Chairman of this session, Justice of the Supreme Court present here, Nigeria and beyond, the Executive Secretary, Nigerian Shippers Council, senior lawyers, senior advocates present here, colleagues, participants, good afternoon. I've been given 5 minutes to make a comment on the topic, demurrage, detention, and storage charges, legal characterization, risk allocation, and global best practices. My name is Chief Osuala Emmanuel Mwabara. I'm the managing partner of Maritime and Commercial Law Partners, Papa Lagos. Now, Dr. Emeka Kabok, Senior Advocate of Nigeria, has given all the background to this discussion and has indeed discussed very comprehensively the issue that I am called upon to comment on. I commend this paper, and I can just say that I adopt everything he has said and sit down. But I just want to say one or two things within the 5 minutes that I'm allocated. And the first thing is to note that demurrage and detention charges in the port industry is not a strange phenomenon. Indeed, it is part and parcel of cargo logistics and transport. I'm talking about the relationship that binds the importer or consignee and the shipping company and the terminal operator. We just have to look at the bill of lading and the terms and of companies' agreements, container user agreements, and tariffs. That is the privity of contract between the importer or consignee and the shipping company. And between the importer and the terminal operator, within the Nigerian port model, we have the concession agreement between the terminal operators and the federal government agencies, which executed that agreement on behalf of all port users in Nigeria. And so there is derived privity of contract inuring to the importer. Having made that point, I have said here that demurrage is part and parcel of cargo, logistics, and transport. And of course, we know the traditional causes of demurrage: inadequate documentation, customs examination procedures, delay by the consignee himself, in picking his goods out of the ports. Those do not present worries to me, and I believe to all of us here. The aspect that presents worries to me is that aspect of charging the consignee for demurrage, which he had no hands in causing. And this demurrage on the part of the shipping company starts counting pre-release and after release. Because by the time the container comes into the port and the shipping company drops it, the shipping company has a number of days within which you should pick the container. If you do not pick it within those number of days, the demurrage starts counting for you. And then when you pick the container after release, if you don't return the container, then detention charges apply to you. For the terminal operator, the moment a consignee is given cargo arrival notice and the containers are dropped, and you are given a number of days as stated in the concession agreement, which I have referred to, it's a public document, the demurrage begins to count at that point, because after the 3 days, the container begins to attract demurrage, or whatever cargo begins to attract demurrage. Now, why are we worried about demurrage then? We are worried about demurrage, aspects of demurrage, whether you call it detention charge or demurrage charge, depending on whether you are referring to the terminal operator or the shipping company. That aspect that was not caused by the importer of the cargo. And in my own slide here, which I'm not able to show, I have identified just a few instances where the courts or any adjudicatory body should pay attention to. First, I identified the issue of block stacking of containers, where a terminal operator stacks containers 5 containers high, instead of, say, 3 containers which the Nigerian Ports Authority prescribes. And then it takes a while before these containers are positioned for examination due to faulty reach instruments
equipment. You know the equipment, you have to bring down the container for positioning for customer examination. In between, you have 4 or 5 days delay caused by the terminal operator who bears that part of demurrage. That's one of the problems. You also have a situation where the shipping companies and the terminal operators, between them, agree to discharge a container in a port to which that container is not destined to. A container is destined to a port, is discharged at Tinkan Island. It takes some time to locate that container. In between, the 3 days are gone. Who bears that demurrage that will accrue in between, caused by this agreement that the consignee is not part of? Even for road terminals, you see cars that are parked, car spaces are overused. After release of the cars, it takes 2, 3, 4 days for the owner of the car to pick it out because the terminal operator has to drive out the car. But because there's no space, all of what I am saying are what I have experienced in my practice of close to 4 decades. These are practical cases. Who bears that aspect of the demurrage? These are the questions. And of course, demurrage is not limited to picking up container late and not returning it in time. Even the space that the terminal operator uses. I mean, a vessel comes in, is battered, and after discharging, it does not leave. Again, it's detaining the space. There has to be penalty. And whenever this comes before the courts, what should the court consider? What decision would meet global standards? The courts have been very proactive in some of the cases that I was involved in. That was the case of ENL and owners of the vessel Vasina. The vessel had occupied the idle berths and did not leave in time. The terminal operator charged first day 6,000 and in subsequent days was charging progressively. Issues arose, the matter was taken to court, and AKJ decided that, look, since parties had agreed initially at 6,000, maintain the 6,000 throughout the period the vessel stated there. It was a balanced decision, nobody appealed. Everybody was happy. There are other instances that demurrage can accrue outside the fault of the consignee. What do? We had a case recently where a shipment of cars was made from America to Spanish port, transshipment port. It landed in Nigeria, and the shipping company refused to release the cargo because they said the Spanish border control authorities failed to examine the container, and they threatened to take this container back, containing a Lamborghini and other exotic cars, total consignment worth over 2 billion naira. We had to fight and threaten to go to court before the cargo was released. Meanwhile, demurrage was being calculated for the consignee. What happens in this kind of situation? So, I just have 1 minute to go. I have examined all of this in my presentation, and I made some recommendations. Part of my recommendations is that we already have enough laws here. We're expecting that the president would assent to the Nigerian Port Economic Regulation regulatory agency bill, where we are praying that the president should assent it quickly, so that Nigerian Shippers Council will begin to play the role that the commission in the USA, which the Federal Commission in the USA is already playing that role of regulating the charges. And we also identified the fact that the Federal High Court in 2018 has instituted a mediation center. It should be activated. That mediation center can take a lot of work off the shoulders of the judges. There are neutrals who have registered as mediators. We can deal with such cases at that level, which is an institutional mechanism to reduce conflict. Parties will meet, agree, and of course, that would aid what the companies are already doing, granting waivers where it is clear that it is not of the consignee's making. So we have recommended that, and we believe that by the time you get my slide, I said a number of things. Even the insurance that my learned friend talked about, Dr. Emeka Kabok, senior advocate, that insurance was, the Insurance Act was enacted last year. None of my clients have patronized any insurance company because they feel that the amount is too small. The amount of insuring the return of a container is too small to incur further damage, further expense on the consignment, and so it's not working. It's a law, but it's not working. I've made far-reaching recommendations in my slides. By the time you get it, you will see how helpful it will be to accord with best practices that we know globally. Thank you very much for your patience.
Thank you, Chief Wabara. Chief Wabara took injury time 5 minutes in addition to his own 5 minutes. I'm used to him. He will say in court finally and in conclusion, and all of them will come. My Lord, the Honorable the Chief Judge of the Federal High Court is here with us. I don't know why my Lord will not come and sit with the Chief Justice of Kenya so that we see you. I've learned very fast from the President of the Chief Justice of Ghana to come and push Chief Wabara out. Like I said, this is not a topic we should rush at all. But again, let me call quickly on Mr. Adekunle. Please leave out your introduction because I'll bill it on your time so that we also don't enter the mortgage. Please. Thank you. What would that mean?
Thank you. No problem, sir. Good afternoon, everyone. Good afternoon, my lords, distinguished guests, ladies and gentlemen. Thank you for giving me the opportunity to stand before you today to present on one of the most widely discussed topics in the maritime sector. Dr. Emeka has said a lot on this topic, and I don't think I want to reiterate anything here. The definitions, the application of D&D has been well stated, but I would just want to add to the recommendations that he has put forward. I totally align, but just to add to some of it, he mentioned on something on visibility earlier, and I think it's something we all need to adopt in terms of driving automation of the end-to-end clearance process within the port. The Nigerian Customs has started something through the National Single Window, trying to bring on board NAFTA, SON, Customs under one platform. As Dr. Emeka has said rightly, other stakeholders also need to be incorporated. It's still work in progress, and we hope that we will get there so that we can also compete with the rest of the world. Then another thing that also affects customers in terms of incurring, especially detention or demurrage, as the case may be, is infrastructural issues that we currently have. And the minister said something on Wednesday regarding the Nigeria-UK financing agreement to modernize the Apapa and Tinkan port. I'm very optimistic that by the time this is completed, we'll have full dividends of this, and issue of demurrage detention will be reduced to some extent in the sense that trucks can then move easily into the port to load and also go in to drop empties as the case may be. And I think lastly is the continued education for our cargo owners in terms of getting their documents ready at least before 7 to 10 days before vessel arrival, so that the clearance process can commence even before the vessel arrives. And with this, I think we can jointly reduce the issue of demurrage detention and storage at port. Thank you.
Thank you for keeping to time. May I quickly call on Mr. Emenike? Allow me, like they do in the letters, I will not call the last name because I will murder the pronunciation. If you keep to time, I don't know the organizers how they want to do it for question and answers, or whether when we come back after lunch. Like I said, this is not the topic you rush. After it's 5 minutes, I'm not going to make any comments except to thank them and then say again, repeat who they are. So, if you have any injury time, summarize it. Yes, fine. Thank you. Good
Good afternoon, all. Due to want of time, I will just go straight to the essentials of what I prepared on behalf of my association as practical operators of all these laws. I will start by instances. We have a case, somebody imported matches, the matches we use, and during examination, custom discovered through the books that he required end user certificate, which is a certificate from the DSS or National Security Advisor, and they asked him to go and obtain that. And he moved to obtain that document. It took him some time. DSS, it's not an office you can just walk in and walk out. By the time he came with the document, custom did all the releases, perfected the releases, issued him exit and everything. He moved to shipping company calculated demurrage, and he came to a whole lot of millions. While he wrote the shipping company for a waiver, while waiting for the waiver, container was sold auction. This is practical. Now, since the detention was caused by Nigerian customs because they needed a particular document, ordinarily a letter should have been written to shipping company to suspend such charges. That is just one. If we go on again, because the essence of this discussion is about detention, storage, and you have loaded a container to a company, and the container got there, and the company, they are not ready to upload immediately, and they delayed the container for some days. By the time the container is discharged and the empty is returned, the terminal operator, the receiving bay is not ready to receive the empty, and the empty container is hanging on the truck for days, waiting for clearance on where to drop the container. This is more in Lagos. And at the end of the day, by the time you have managed to go through all this, your container deposit refund is all gone. The last before me mentioned about resuming clearance process 10 days before the arrival of vessel. Yes, an importer is eager to have his cargo. The shipping lines, are they eager to submit manifest and perfect? Because everything is now. Without the manifest being submitted, there is no way you can resume clearance. And then I will give another practical, a vessel arrives. Like the lead speaker said, the vessel is on time charter, and all the containers are hurriedly dropped by the shield side for the container to leave. And while the containers are at the seaside, the terminal operator is now moving them to the terminal in batches. Within the period of stacking it at the seaside and transferring it to the terminal, for you to have access to the container, 7 days are gone. Your 3 days are gone. And yet, the shipping company will charge you from the date of discharge, even when you do not have access to the container within those 3 days. A whole lot is happening within the maritime industry, particularly this. And we talked about custom examination. You are ready to examine your container today, and you apply to the terminal operator, and the terminal operator will give you a date next week for you to come for examination, because it will take them that number of days to eke out the container. Who pays within those days? Then we have government agency interventions. After physical examination, one of the agencies will tell you they are not satisfied.
that they need the container to be redocked for them to satisfy themselves. And meanwhile, in the port, you can't report to anybody. While you are reapplying for redropping, demurrage is mounting. Port congestion is light now. Shipping line rescheduling of their arrival dates. Shipping lines submit manifest to customs. And the moment the manifest, which is e-manifest, is submitted to customs, customs starts counting the days. From the Act, Custom Act 2023, you have 27 days within which to remove your container from the port. And within these days that the manifest was submitted to the point the vessel batted and container is transferred to the terminal, you may have only 5 days left. In the course of trying to move this container, they will tell you that the container has entered over time. And we talk about terminal equipment failure. Once a terminal is receiving a vessel, they move all equipment to the seaside. They give priority to discharging of that vessel because the payment is in dollars. So every other activity should wait. Loading, receiving empty container, because there's no equipment. All equipment is within the seaside. And yet, they will ask you to pay. Network failure. You are ready to raise their debit and the terminal operator, their network is down. But let me just close with this due to want of time. It's unbelievable that right now so many shipping companies still raise their invoices outside Nigeria. Some of you may not have heard that. You apply online, the invoice will be generated outside Nigeria. Sometimes it can take 3 days. And yet, it's not calculated among the days that you are supposed to enjoy free. I thank the Shippers Council for this opportunity. I wish and I pray that this topic of detention and storage will require more time than what we have been allocated. But all the same, thank you for this opportunity.
Thank you so much, Mr. Emeneke, and I apologize for not calling your surname. If the justices of the Supreme Court gave 2 questions for 2 men and 2 women, having just retired from the Federal High Court, the Gateway Court, and the Court of Original Jurisdiction, I will only give 2. And 2 questions, and if no comments, but if there are corrections, I will extend time we take. If someone wants to correct or disagree with what you said, but not Professor Olawe, because we will not leave you until after 1. So if there are questions, please let us, on a very serious note, let us have them direct because of want of time. I said no, Professor Olawe, it looks like you. No, okay. 1. Okay. Professor Olawe said, you can see I'm still powerful. Yes. Okay.
Thank you very much for the privilege, sir. My name is Soya. Presently, I'm a freedom show. Power overseas investment in power sector. I have been in the Maritime economy. Russian department has to do with the Maritime Service department. So my question is that, okay, I want to say something. I want us to help Shippers Council to be able to live to its expectation, most especially in the area of coordinating all the agencies that are enforcing or that have one role or the other to play at the ports. National interest is not driving there. And therefore, if we're able to help Shippers Council to coordinate as well as enforce and possibly report if there's any reason for fraction or refusal of one of the agencies to comply. Nobody is above the law, and that's why we're here. And I think that will help Shippers Council to see that regulatory role very, very well. The number two,
you have overruled me, you are making comments. We're asking for questions. We all have our own. Yes. Yes, the Baba. We know you, but you can introduce yourself.
Respectfully. My name is Admiral Ladinjo. The demorage that we have described today refers to demorage in Nigeria. Can there be a situation where a Nigerian exporter is asked to pay for demorage where the destination consignee failed to clear his goods at the destination? Can there be? And if there can be, who should be liable? The agent or the cargo interest? Thank you.
Dr. Akamoku, the engine room of Admiralty is asking you. So bearing in mind the time we have.
Thank you. The bill of lading is a contract between the carrier and the shipper. So the contractual parties could be the shipper or the consignee. So in this case, if the party in Nigeria, the exporter, is the shipper, then that bill of lading still binds that shipper in the event that the consignee has not been endorsed to any other party. But the circumstances in which a shipper who has essentially completed the responsibility here in Nigeria will be liable really would be one in which the container probably has to return. And I've had cases where the shipper is sued for a container which was not delivered at the destination. So the particular circumstances of the case will eventually determine it, and including the terms of trade upon which whether it's a CIF or FOB, whatever it is, but that would be my comments on that. Yeah.
I thank you, organizers. Before I leave the podium for co-opting me as a chair, but one case, food for thought. The case of Ferguson Sura, a Nigerian doctor from Germany, imported 2 cars and medical equipment. They were actually in the manifest. The Mercedes 230 was seen in Ghana. It was said to be offloaded in Lagos. It was never seen in Lagos that they went to Wari, they couldn't see it. He rushed to court, came to Federal High Court, filed a matter in court. Justice Olomo Jobi retired and had the case. Up to the time of her retirement, she could not deliver judgment. The case was transferred back to Achibong, who adopted the proceedings in the evidence in the former court, and the Court of Appeal disagreed that it was a lazy approach. And the matter came back. I had it so many years after. By that time, nobody was using Mercedes 230. And I said, even if they have found it, what will have happened? I don't know what it is. I mean, this is a food for thought. So when we go and get money in the bank, we get bills of lading, all this grammar, the whole thing is again a sense of time. All those things, even the demorage thing is want of time. So thank you so much for giving me the opportunity to chair, even though I did not know I was going to chair. And I thank you so much, Dr. Akabogo. They are my teachers, Chief Wabara, and they are not with us. Thank you so much. Thank you so much for also giving us the insight, and I'm sure you get the papers. He's saying how many questions? I said questions, and the people made comments. But I think Chief there asked a question. I think you can do the other ceremonies. But I know we are going to come back. This is not something we do rushing or on the scrap or something. But I already made my complaint that if you are fixing this type of program, take regards to the days. Don't fix it on a Sunday, don't fix it on a Friday at 1 to 2 o'clock. It will rush us, and rushing is not good for legal argument. There's always the other side to it. I thank my Lord, the Chief Justice of Ghana, and my Lord, and my Lord, the Chief Justice of Kenya. I'm looking forward to my invitation, and I'm happy we are all here. And my Lord Justice Danjuma, I thank you. It's not in my place to do vote of thanks, but I also thank Mrs. Ofon Usoro. I know it was her conspiracy to co-opt me as chair. Thank you so much too.
Please can we put our hands together for my Lord Honorable Justice Ibrahim Buba, retired Judge of Justice of the Federal High Court. Let me also welcome with all of us the Chairman Central Planning Committee for this very important seminar, the Chief Judge of the Federal High Court, my Lord Honorable Justice John Soho. Please let's welcome him with a round of applause. We appreciate your presence here this afternoon, sir. Before we bring it to a formal close, it will be pertinent that we also take a few moments to listen to the presentation of a communique. After the communique is presented, I's dotted, T's crossed would ratify, approve, and then of course after which we'll be taking the closing aspect of this. But before then, it is also pertinent to let you in on the fact that one amongst us will be doing us the honor of presenting this communique. He was one of our lead presenters yesterday, and I'm talking about Professor Wale Olawoyin SAN. Please let's put our hands together for him as he comes forward. Yes, just before we bring this session to a close, do me the honor of joining me as I welcome my Lord, the Honorable Chief Judge, Chief Justice of the Federal High Court, to please join us here. ES, CEO of Shippers Council, my Lords, the visiting Chief Justices of the various countries participating. Please let's join these panel, a group of persons for a group photograph, after which we'll continue with the presentation of this communique. Please, Professor Olawoyin, just spare us a few more minutes. We'll be inviting you up shortly. And then I don't know if we still have copies of the book on the 17th edition of this International Maritime Seminar. If we still have those books, can someone bring some copies here for us for symbolic presentation? My Lord, the Chief Judge of the Federal High Court will be in the middle, sandwiched by the ES, and then the rest of us can follow suit. Thank you very much, the host of this event and the Chairman of the Central Planning Committee. Please hold on a little bit, my lords. Please hold on for the symbolic presentation for those of them who were not privy to be here yesterday. No, can we have more, please, quickly? They bring in more. If you participated and you don't want to, okay, all right. But this is okay, thank you very much. We'd like to appreciate all of you for participating. Please can we give all of them a deserving round of applause as they return to their seats. And we're also grateful that the Chief Judge of the Federal High Court, who doubles as the Chairman Central Planning Committee for this 18th International Maritime Seminar for Judges, is here with us in flesh and blood, and I like that he has left everything to be with us here. Please let's applaud him one more time. The Lord will appreciate your presence. I think at this point in time, from the table of our rapporteurs, is there anything we're adding or is there anything we're subtracting so that we can invite Professor Olawoyin SAN to do us the honor of presenting this communique before this august gathering? And I'd like to plead that we put pen to paper so that in case there are corrections to be made, dotting of I's or crossing of the T's as may be necessary, so we can all pick that. Please put your hands together one more time, Professor Olawoyin SAN.
Thank you very much. Good afternoon, my lords, the Chief Judge of the Federal High Court, and all the Chief Justices here present. Permit me to read out the final communique that we have for this sessions that we've had in the past couple of days. What I'm going to do, because of time, is that apart from the preamble, I am just going to be reading out the recommendations for each session, and I'll read it all the way through, and then if there are any comments, we will take the comments. So in terms of the preamble, we, the participants of the 18th International Maritime Seminar for Judges, convened at the Ladikwali Hall, Abuja Continental Hotel, Abuja, from Wednesday 22nd to Friday 24th July 2026, under the auspices of the Nigerian Shippers Council, under the joint auspices of the Nigerian Shippers Council and the National Judicial Institute, in collaboration with the Nigerian Maritime Law Association. Having deliberated over 3 days on the theme, building capacity and bridging gaps in navigating the dynamics of maritime law through an opening ceremony, 5 technical panel sessions, and a closing colloquium, having been honored by the presence of and active participation of the Honorable Chief Justice of Nigeria, the Honorable Justice Kudirat Motomori Olatokunbo Kekere-Ekun, GCON CFR, who declared the seminar open, the Secretary to the Government of the Federation, His Excellency Senator George Akume, CON, who chaired the opening ceremony, the Honorable Minister of Marine and Blue Economy, His Excellency Dr. Adegboyega Oyetola, CON, who delivered the keynote address, the Chief Justices of Kenya, Sierra Leone, and the Gambia, and judicial delegations from Ghana and Liberia, Justices of the Supreme Court of Nigeria, the President and Justices of the Court of Appeal, the Chief Judge of the Federal High Court and Chairman of the Organizing Committee, Honorable Justice John Thema Soho, OFR, and judges of the Federal High Court, the Chairman of the Governing Board of the Nigerian Shippers Council, His Excellency Dr. Ibrahim Shehu Shema, CON, FNIM, judges of the State High Courts, the Administrator of the National Judicial Institute, Honorable Justice Babatunde A. Adejumo, OFR, retired, the President of the Nigerian Maritime Law Association, Chief Michael Igbokwe, SAN, the Managing Director of the Nigerian Ports Authority, Dr. Abubakar Dansoho, the Permanent Secretary, Federal Ministry of Marine and Blue Economy, Mrs. Fatima Sugra Mahmood, and a distinguished gathering of judges, maritime lawyers, scholars, regulators, and industry leaders from Nigeria, Africa, and the international maritime community, and recognizing that a credible, expert, and efficient maritime justice system is a strategic national asset, a precondition for the realization of Nigeria's blue economy ambitions, and a critical signal of confidence to the international investment and shipping community, acknowledging the commitment made from this platform by the Secretary to the Government of the Federation that the Office of the SGF will actively support the implementation of actionable recommendations arising from this seminar, including through legislative engagement, convention ratification processes, and interagency coordination, do hereby adopt and declare the following as the final communique of the 18th International Maritime Seminar for Judges. And then we had the opening ceremony with all the speeches, and there were the following commendations to the attention of the relevant authorities. The first one, the President of the Federal Republic of Nigeria is respectfully urged to assent to the Nigerian Ports Economic Regulatory Agency Bill without further delay. The establishment of an independent economic regulator for Nigerian ports is essential to the coherent governance of port concessions, the protection of port users and service providers, and the attraction of sustained investment into the maritime sector. 2, the National Assembly is urged to enact the pending amendment to the Admiralty Jurisdiction Act as a matter of legislative priority. The amendment is necessary to resolve the tension between the Act and the Admiralty Jurisdiction Procedure Rules 2023, to clarify the legal basis for arrest in support of foreign arbitration and foreign litigation, and to align the standard for wrongful arrest with modern Admiralty practice. 3, the federal government is called upon to sign and the National Assembly to domesticate the United Nations Convention on the International Effects of Judicial Sales of Ships 2022, the Beijing Convention, which entered into force on 7th February 2026. Nigeria's absence from a convention that now binds 34 states, including several African neighbors and the leading maritime registry and trading nations, has direct consequences for the enforceability of Nigerian judicial sales abroad, the bankability of Nigerian flagship vessels, and Nigeria's standing as a maritime hub. And 4, the Office of the Secretary to the Government of the Federation's commitment to support the follow-through of seminar recommendations is formally noted and welcomed. Participants call upon that office to give institutional expression to this commitment through a structured implementation tracking mechanism with identified focal points and timelines, reporting progress to the 19th International Maritime Seminar for Judges. On day 1 and the first panel, which dealt with the overview of the Admiralty Jurisdiction Procedure Rules 2023, a sine qua non for maritime adjudication. It was moderated by Honorable Justice Martha Koome, Chief Justice and President of the Supreme Court of Kenya, and the lead paper was presented by Professor Wale Olawanyi, SAN, and the panel discussants were Honorable Justice Buba, a former judge of the High Court. And the following recommendations were adopted in respect of panel 1. The Chief Judge of the Federal High Court is called upon to issue formal directions for the immediate establishment of the Admiralty Registry and the Admiralty Division of the Federal High Court as provided under Order 2, Rule 3 of the Admiralty Jurisdiction Procedure Rules 2023, and to designate trained and experienced Admiralty judges to the division without further delay. 2, the National Judicial Council is called upon to deliberate in appointing to the Admiralty Division judges who have demonstrated training and expertise in maritime law, and to extend specialized capacity building programs to court registrars and judicial support staff, recognizing that the quality of Admiralty administration depends as much on the efficiency of the registry as on the expertise of the bench. 3, courts are urged to accept a P&I letter of undertaking providing for Nigerian law and jurisdiction as valid security in Admiralty proceedings, and to resist demands that securities take the form of a bank guarantee from a specific Nigerian institution, which can amount to wrongful arrest or abuse of process, particularly in respect of foreign ship owners. 4, the Chief Judge of the Federal High Court is urged to align Order 3, Rule 5 of the Admiralty Jurisdiction Procedure Rules 2023 with Section 5 of the Arbitration and Mediation Act 2023, so that a matter subject to an arbitration agreement is stayed rather than struck out, and to amend the rules promptly when significant procedural deficiencies are identified, rather than deferring reform to a future generational revision. And 5, the caveat against arrest register should be digitized, following the practice of Australia and Singapore, and the Admiralty Marshal's Office should be equipped with the technical and human capacity necessary to discharge its expanded functions under the 2023 rules, including the exercise of the Marshal's new power to appoint a ship manager. Day 2, which had the second panel that discussed the ship as security for finance and maritime claims, ship mortgage in Nigeria, and the role of the Beijing Convention. This panel was moderated by Honorable Justice Emmanuel Akomaye Agim, Justice of the Supreme Court, and the lead paper was presented by Adedoyin Afun, a partner in Bloomfield, and the panelists and discussants were Kashimana Sumba and Mr. Nelson Otaji. The recommendations of the following resolutions were adopted in respect of panel 2. 1. The federal government of Nigeria is called upon to sign and accede to the United Nations Convention on the International Effects of Judicial Sales of Ships 2020 as a matter of urgent national priority. The convention entered into force on 17 February 2026. Nigeria's continued absence deprives Nigerian judicial sales of international recognition, weakens the enforceability of ship mortgages taken over Nigerian flagged vessels, including those financed under the Cabotage Vessel Financing Fund, and places Nigeria at a competitive disadvantage relative to its West African neighbors who have already signed. 2. Upon accession, the Admiralty Jurisdiction Procedural Rules should be updated to provide for the recognition of convention certificates, the recognition of foreign judicial sales, electronic notices, and the transmission of judicial sales certificates to the repository maintained by the International Maritime Organization through the Global Integrated Shipping Information System platform. 3. The amendment of the Admiralty Jurisdiction Act should include an express provision empowering the Federal High Courts to apply international best practices in maritime matters, including principles drawn from conventions not yet ratified by Nigeria on the model of Section 254C of the Constitution as applied by the National Industrial Court in labor matters. It is noted that such a provision supplements but does not substitute for ratification, since recognition by other state parties and access to the IMO repository depend on Nigeria's status as a contracting state. 4. Courts ordering the judicial sale of a vessel are urged to make express provision within the sale order for the wages and repatriation of crew members consistent with Nigeria's obligations under the Maritime Labour Convention of 2006, and to address this as a priority claim from the proceeds of the sale rather than as an afterthought to the distribution process. 5. The jurisdictional conflicts arising from the removal of seafarers' wages claims to the National Industrial Court under the third alteration to the Constitution, which has effectively deprived seafarers of their maritime lien for wages and of the right of arrest, that is the practical enforcement mechanism for that lien, requires urgent legislative resolution. The maritime lien for wages is one of the oldest protected rights in Admiralty law, and its effective abolition is inconsistent with Nigeria's obligations under the Maritime. And 6, Admiralty matters and applications for judicial sale, in particular, Admiralty proceedings are largely documentary in character and are capable of expeditious resolution. A vessel deteriorating under prolonged arrest serves neither creditor nor debtor and creates environmental and wreck risks and imposes escalating costs on all parties. The courts are urged to treat Admiralty matters as the sui generis category they represent and not to process them on the same timelines as general civil matters. Panel 3 on day 2 dealt with marine cargo claims in the age of port concession, liability, causation, and proof in emerging maritime economies. This panel was moderated by Honorable Justice Kumba Kamanda, Chief Justice of the Republic of Sierra Leone, and the lead paper was presented by Funke Agbo SAN, and the panelists and discussants were Nonso Azi of Azi and Azi Legal Practitioners, Professor Awao I. Magashi of the Faculty of Law, Bayero University, Kano, and Mrs. Chinenye M. Dende, General Manager, Legal and Corporate Affairs, APM Terminals. The very interesting discussions resulted in the following for that panel. 1. The Carriage of Goods by Sea Act 1926 should be repealed by a short amending act of the National Assembly. 20 years of dual regime uncertainty between the 1926 Act and the Hamburg Rules Act 2005 is a legislative error correctable in a single clause, and the correction is long overdue. The appellate courts are called upon in the interim to resolve the 2 Federal High Court decisions casting doubt on the applicability of the Hamburg Rules, applying the principle that the later enactment prevails and giving effect to Nigeria's international obligation to implement the convention it has domesticated. 2. A Nigerian Bills of Lading Act should be enacted without further delay, modeled on the English Carriage of Goods by Sea Act 1992 or the South African Sea Transport Documents Act 2000, and covering order bills, strait bills, seaway bills, bank pledges, and electronic transport documents. The absence of a clear statutory right of the Bill of Lading has persisted for nearly 2 decades since the repeal of the relevant provision in the Merchant Shipping Act 2007, and it is priced into every letter of credit issued against Nigerian cargo. 3. Nigeria is called upon to engage seriously and strategically with the Rotterdam Rules, that is the United Nations Convention on Contracts for the International Carriage of Goods wholly or partly by sea, as the modern unified framework that brings terminal operators within a direct liability regime as maritime performing parties, provides a comprehensive electronic documentation framework, and balances the interests of cargo-owning and ship-owning nations. Nigeria's neighbors, Togo and Cameroon, have already ratified. Nigeria participated in the negotiation of the convention and should not remain on the periphery of its implementation. 4. Nigeria should ratify or enact a domestic equivalent of the United Nations Convention on the Liability of Operators of Transport Terminals in International Trade, 1994, so that the liability of terminal operators is governed by a clear and defined legal framework with known limits and mandatory insurance requirements, rather than by concession contracts and standard handling conditions that frequently replicate or undercut the carrier's Hague Rules limitations. 5. Courts adjudicating cargo claims in the post-concession port environment are directed to approach liability as a function of custody and causation rather than of visibility. The correct discipline requires the courts to identify the last reliable condition checkpoint before damage, reconstruct who had physical custody and who controlled the operative risk-producing function at each material time, test the alleged causal mechanism against the contemporaneous records, and apportion liability only where breach and causal contribution are proved. Damage is discovered at the terminal is not damage caused by the terminal. As 6, practice directions should be issued by the Chief Judge of the Federal High Court for the Admiralty Division requiring compulsory disclosure at the earliest stage of proceedings of automatic identification system data, terminal operating system event logs, reefer temperature records, equipment interchange receipts, gate timestamps, and relevant closed-circuit television extracts in all cargo claims where the condition of the cargo at a custody transfer point or the cause of delay is an issue. 7, the liability of state agencies, including enforcement agencies operating holds and inspections within the ports, for delays caused by their own directions must be placed on a clear legislative footing. It is unjust and indeed commercially unsustainable that terminal operators and shipping lines are compelled to grant waivers of storage and demurrage accruing during agency-imposed holds, while the agency bears no legal consequence in some cases of investigations that conclude without any adverse findings against the cargo or the importer. And finally, 8, the recharacterization of maritime contracts as simple contracts, clothing state high courts with jurisdiction over matters that are unambiguously admiralty in character under Section 2(3) of the Admiralty Jurisdiction Act must be corrected by the appellate courts. The exclusive admiralty jurisdiction of the Federal High Court under Section 251G of the Constitution is a constitutional allocation of competence that serves the coherent and expert administration of maritime justice and must not be eroded through progressive judicial recharacterization. On day 3, we had panel 4, which discussed aligning Nigerian maritime dispute resolution with global practice, arbitration, courts, and the future of hybrid justice. This panel was moderated by Honorable Justice Samuel Kwame Adipo-Asiedu, Justice of the Supreme Court of Ghana, who is representing the Chief Justice of the Supreme Court of Ghana. 2 lead papers were presented, the first by Honorable Justice Olayinka Faji, Judge of the Federal High Court, on the alignment of Nigerian maritime dispute resolution with global practice through arbitration, the courts, and the hybrid justice system delivery, and the second by Mr. Edward Alder, a barrister, and the Vice President of the Hong Kong Maritime Arbitration Group, on the Hong Kong experience in maritime dispute resolution. A third presentation was delivered by Honorable Justice Mohammed El Shuaibu, OFR, Presiding Justice of the Court of Appeal of Akure Division. And the President of the Court of Appeal, Honorable Justice Monica Dongban-Menson, CFR, was represented by Honorable Justice Mohammed Ambi Usi Danjuma. And the discussions on the panel were quite extensive, and the following resolutions were adopted in respect of panel 4. 1, the National Assembly is called upon to amend sections 19 and 20 of the Admiralty Jurisdiction Act without further delay, on fusion between foreign jurisdiction clauses and foreign arbitration clauses embedded in section 20, has generated 2 decades of conflicting appellate decisions, deprived Nigerian parties of the benefit of their own arbitration agreements, and undermined